Welcome back to our streaming coverage here at the Wisconsin Live Desk. Yep, we are still here. It's 6:40 p.m. on Thursday, December 18th. It's been 8 months to the day since Hannah Dugan allegedly helped a man in the country illegally to evade ICE agents at the Milwaukee County Courthouse. She is charged with doing so, and a jury is currently deliberating. What's it been now? It's been 4.5 hours.
4.5 hours, yeah. The pizza has been ordered, presumably eaten, and they are contemplating the fate of Hannah Dugan right now. Testimony today, very fascinating, in day 4 of this trial. Closing arguments, of course, were heard today. They wrapped up, and now it's the waiting game. The one thing that we do know, Brian, that we surmised earlier is that, okay, will they break for the evening and then come back tomorrow? Clearly, the indication with them saying, we're going to hang out, we're going to have some dinner, we're going to be talking about 1, 2, 3, 4 things that are a sticking point between us. They want to get this done, hopefully, tonight, but clearly they're sticking around.
Yeah, they seem invested in getting it done tonight, but they still have tomorrow before we break for the weekend. It's always possible they could break later tonight. We'll wait and see. I do want to catch people up. If you're just joining us, if you haven't been following this all day, if you've been following us throughout the week, you've heard nothing but talk about government witnesses. 19 witnesses, more than 15 hours of testimony. And then today was supposed to be the defense presentation. If you blink, you missed it because it was 45 minutes long, just 4 witnesses. Now, I will point out, and many will say, the defense got its case in along the way by cross-examining all of those state witnesses. So it's not like the defense did nothing. They certainly were cross-examining each and every state witness and laying out some of the holes they were poking in the state's case. But as far as calling its own slate of witnesses, just 4 in 45 minutes today.
Yeah, just 4. And we know that those, the other 19, from yesterday were whittled down from 28. And the judge had said at that time, things are going along, swimmingly. Things seem to be going along without a hitch. There were some hangups. Jason Kelvey talked a little bit about today, or I don't want to say hangups, but focal points. And one of those, Brian, that we saw today was this flash drive. This flash drive that they were talking about that they had wanted to see.
That's just a matter. The jury wants to see a couple of exhibits.
Sure.
They want to check some of these things out, and the judge said they asked for one specifically, Exhibit 7, I think it was,
Exhibit 7.
which is an ICE internal document, and the judge just said we're going to give it to you on a flash drive.
Right.
That way you plug it in, you pull it up, you look at it. Yeah. I do want to say that because Ted Perry's standing by the federal courthouse, we're going to go to him and we're going to talk about some of the stuff that's happened with these exhibits. But first, I just want to talk about what happened in those 4 witnesses, because there were only 4. 2 were sitting Milwaukee County judges, and only one of whom was really on the stand for any significant length of time. Then there was a public defender who had taken pictures of the ICE agents and said she was not happy that they were there. But she apparently had no direct contact with Judge Dugan, and that was kind of the defense's point in bringing her up. She'd been mentioned as the person taking photos, but later said she never had any contact with Judge Dugan. The last witness,
the most interesting,
the one that they landed on, ended their testimony with, was former mayor of Milwaukee and former candidate for governor in Wisconsin,
Tom Barrett.
Tom Barrett.
Which we speculated on that yesterday. Will he be called up? And clearly, this was Tom Barrett being called up, a character witness. The jury's not going to know about their relationship or the relationship that he has with the judge, but clearly, what most of us thought at that point, you would agree, is this was a political maneuver, was it not?
Well, that's what we've talked to Mordecai Lee and others about, and Jonathan Lavoie, who we're going to talk to in a little bit. Why Tom Barrett as that character witness? Because there are a lot of people who could attest to Judge Dugan's character over the years, what kind of a person she is. Why Tom Barrett? Well, he is a well-known Democratic politician, and that's someone that the jury might get the hint that this is. The defense wants the jury to think about the political implications of this. The federal government does not want them to think about that. They want them to think about the facts of this specific case. What the jury is thinking about, though, we don't know, because we're not in that room. Yeah. But I know that we're getting a little bit of a hint. And Ted Perry is at the federal courthouse right now. You've had a long day as well and a long week. But Ted, we've heard a couple of knocks on the door, and then the jury sends out a note. And then we hear what's in that note. First of all, what's been in these notes so far, and what is it telling us maybe about where the jury is spending its focus right now?
Well, you mentioned the flash drive, so that's one. The other one was a question of, it was a really good question, if you think about it, from jurors. This was about an hour and a half ago. They wanted to know, did Judge Dugan need to know the name of the man who was on that warrant, Eduardo Flores Ruiz, or not? And they brought both sides together, And it was decided after some deliberation, according to Judge Edelman, that yes, she did need to know the name, and that's where that was sent back to the jury with that answer there. At 18:35, which is just about 10 minutes ago, Bill Miston, who's up in the courtroom reporting another knock on the door, waiting to get an update from him to see what that's all about.
It's our third knock on the door. We do know that in between the second knock and now this third knock, we know that the jury had a really important question for the judge. When are we getting dinner? They got pizza delivered. That was about an hour, a little over an hour ago that they asked about the pizza, I'm guessing. I don't know if it's actually been delivered, if anybody's seen the pizza boxes coming into the courthouse or not. But this third question, we don't know what it's going to focus on. It does seem, though, and I don't know, you tell me, because I read Bill Miston's notes, that after the last, there was that second knock was over that jury instruction, and do they need to know the identity of the person named in the warrant? After the decision was made how to word that and send it back in, that yes, they need to know that Hannah Dugan would have needed to know the identity.
Dugan would have needed to know. Yeah.
Bill said it seemed like the defense was kind of moving a little more lightly. Like the defense is seeing this as a good sign, some of these questions that they are asking.
Yeah, there was an interesting exchange between the attorneys. I was not in there at the time. I was down here, but Bill talks about it. And for the defense, it was Nicole Masnica, and I think it was Frayling for the prosecution. And I'm just reading Bill's notes here. They were going back and forth, and at one point said, Nicole Mastica says, the legal answer is yes, so why don't we just answer it that way? There was some discrepancy, and then finally the judge said, look, we don't have an agreement, but we're close, so we're going to go with this. And that's when he came out and said, yes, they do in fact have to be able to, she did have to know the name on the warrant.
And we can talk about this out here.
We are in the waiting game now. So
we can talk about the implications of that, Ted, but it's as Bill put kind of in his own sort of side notes, it's interesting to think that how could Judge Dugan have known to have sped up Eduardo Flores Ruiz's case if she didn't know who the warrant was for? But did anyone actually ever tell her the name? And is there any evidence in the record here that anyone told her that's who it was?
I can't find it. That's why I really think, and kudos to these jurors, because they are clearly taking their role seriously. I went through my notes and I could not find that exchange or a question about that anywhere. So I think it's a really astute question. Or did she just look at her docket, see a name, a Hispanic name, and thought, oh, this must be the guy they want for my courtroom, and that's why she moved Walter Peel, the defense attorney. He had an OWI case, a client in there. He was supposed to be first in the docket, got into court first so he could be first because he had to get to Madison. She called him, then she said, step back, Mr. Peel, come on up here, Miss De La Rosa, and that's when the whole exchange about take the stairs,
Ted, to that point, there was one other piece of testimony that hasn't really gotten much mention, but I think there has to be some significance here, and that is that after moving through Eduardo Flores Ruiz, Judge Dugan gets back on the stand, and she's about to call Mr. Peel back up. Okay, we'll hear you now. And she goes, hang on a minute. Is there anyone else here who needs an interpreter or anyone else who looks ... We never hear how that trails off.
And was that code for, is there anyone here who might be in this country illegally?
But I now wonder if that actually works for the defense.
But that thought was never completed on.
But I wonder now if that works for the defense in a way, because maybe she didn't know which defendant they were after. Maybe she's saying, we got to clear them all out of here because I don't know which one they're after. I hadn't thought about that earlier, but now that we hear this question from the jury, it certainly makes you wonder.
But look, let's give a lot of credit to both sides of the aisle here. There's some really brilliant people who are prosecuting this case and defending this case. So it's a fun thing for us to speculate, but I've got to think with the brain power on that defense team, if it was an important point, they would have brought it up. Don't you think? I mean, I don't want to get too cute by half here and say, well, why didn't you? But I do have some questions about why certain things were done one way or another, which is why I'm looking forward to John. Who's coming on for us tonight?
It'll be Jonathan Lavoie coming up here shortly. And by the way, when you talk about the smart people, I still think it's fascinating. Every one of these government lawyers, Mary, Richard Froling, Kelly Brown Watzka, Keith Alexander, every single one of them was appointed to their current job. by Stephen Biskupik when he was U.S. attorney. He is now the defense attorney, lead defense attorney for Hannah Dugan.
On the defense team, right.
You guys both beg the question, though. If, hypothetically speaking, common sense would say, okay, she knew the name, she knew who it was. But if we can't find evidence of that, if I'm on the jury and you can't give me concrete evidence to that, hypothetically, can you convict beyond a reasonable doubt?
Yes, because the judge gave the order back. Well, the judge said she did need to know the name. So that's a really good question. Will that be a sticking point in that jury room? That's an excellent point you bring up there, Mary.
And it may well be that there's only one person with that question.
Hold on, we're just getting an update. Getting an update here from Bill Miston. Edelman is back on the bench. The jury is asking, I'm going to quote Bill directly, "We desire clarity whether Dugan needed to know the identity of the subject pending proceeding." Froling, the answer is no. And now Nicole Maznicka is saying, here's the actual proceeding. So they're going to be talking about this point again, the same point that they brought up about an hour or so ago. Apparently, it's still unclear to them because they're asking for more of a clarification on this. So.
Yeah. So
Maznicka
is giving the actual I thought that this question was answered, though, by the judge. Are they showing the actual physical, concrete evidence here?
Whether she needed to know the identity of the subject of the proceeding, it seems like that's what they answered earlier.
Okay, Maznicka, they do have to conclude that the administrative arrest of the client, EFR, Eduardo Ruiz, was taking place, and she knew it was taking place. That's what's been presented to the jury. So apparently, the defense did bring that up at one point.
That was the second knock on the door earlier. They asked that very question, and I thought that had already been addressed. So it seems like a repeat question. It seems like they still have some within the room. They're still not quite getting what that means.
Mm-hmm.
Yeah. And so we're getting this from Bill, who's in the courtroom. And, if viewers are just saying, well, why don't we just hear from Bill Miston? Well, you can't, because you can't have cameras in a federal courtroom. And later we can talk about why that is, because there's a fascinating historical background to that. But let's stay on this case for now. Bill is sending notes down to us on a email chain that we're all on up to the minute. Now, okay, the government is saying it's not applicable. The indictment gives sufficient notice that she was aware of pending proceeding for removal proceedings. They don't have to know specific identity of subject pending proceeding. You don't change the law to fit the facts. There is no requirement that the individual be identified in the statute. And they gave the example earlier, guys. The prosecution did. And we're going to get to this is a fascinating back and forth. But the prosecution basically said earlier, look, if you see a guy being arrested by the cops and you go and you help him get away from the cops, or you intend to help him get away from the cops, you don't need to know his name. You don't need to know what he was being charged with. All you need to do is show intent that you were trying to help him get away. That, according to prosecutors, that's all you need. Okay, we just need to show that you interfered with a official proceeding.
Well, and as Maznicka has just said, it doesn't matter. Bottom line, you can't look at the elements. You look at the law, at the statute.
That's what the defense is saying.
Yeah, and the defense is saying, hey, listen, applying instruction elements the way it was charged, if they conclude there is some proceeding pending, and she knew of some proceeding, it would muddy the waters, and there has not been notice to Ms. Dugan. And we're still filling in the blanks.
So what we're seeing is this back and forth between the two sides as to how does the judge go back and instruct and or clarify this to the jury in a way that may influence what they do. The jury's clearly hung up on this bit. What we don't know is, again, as I said earlier, is this one person that they're trying to flip because they're 11-1, or is there widespread disagreement or confusion among the jurors? But what's clear, because we don't know that. What is clear is that this particular point is hanging somebody up in that jury room, at least one person, if not more.
At least one person, right, Brian. So we may be here for a while. But, a while, guys, with federal deliberation, it's a relative term, right? Because I don't know if you saw top of the 6 o'clock news tonight, I pointed out the case of McClure versus the city of Long Beach, Raise your hand if you've heard of that case. I hadn't.
I
until
have,
Googled
only because you said it
Why
earlier.
Is that? Yeah.
I learned
the
it from you.
longest federal deliberation in history. 4.5 months that jury deliberated.
Okay, but
I don't
Ted,
think we're going to get that
Ted,
record tonight.
No,
but
you did
yeah.
that, and I took your lead. So I said, I wonder what some famous Wisconsin federal cases have resulted in
Okay.
federal or state cases, actually. Famous Wisconsin
You're always
trials.
You're always one-upping me, Brian.
I'm giving
Go
you
ahead.
credit for a great idea, but I said, let's go a little further with that. Let's take Ted's great idea and go one
Okay.
step further, and that is Mark Chmura, former Green Bay Packer. Jury deliberated, now this is state
yeah.
court, jury deliberated 2 hours and 15 minutes. He was acquitted. Darrell Brooks, the Waukesha Parade tragedy incident. Jury deliberated about 3 hours. He was convicted. 3 hours was probably just because they had so many counts to go through. Jeffrey Dahmer, obviously well known, serial killer, Milwaukee. Jury deliberated 5 hours, convicted. Stephen Avery, 6 hours, convicted. Kyle Rittenhouse, that would be the Kenosha riots and the shooting that occurred there. 26 hours of deliberation over 4 days. He was acquitted. And Frank Balistrieri, casino skimming, way back in, what was that, the 90s maybe? 30 hours. And he and all of his cohorts were convicted. Now, what's interesting is I couldn't find a case similar to this one because there isn't one. There's not a case like the Hannah Dugan trial that you can compare where there's a judge on trial for actions in a courthouse.
And there's a good reason for, Brian, why there hasn't been one, because it has been the long-standing policy of the federal government, especially under the Biden administration, especially under the Obama administration, that deportation arrest would not happen in certain places. They wouldn't happen in churches. They wouldn't happen in schools. They wouldn't happen at a funeral or even a wedding for that matter. And they certainly wouldn't happen during a court proceeding. And that is what really this whole case comes down to, is the extent of where can these arrests take place. There is no official policy, according to Milwaukee County. They started talking back in March about the need for a policy. What are we going to do? Times have changed. The Trump administration, when they took over in January of this year, made it very clear that they wanted to round up as many people who are in this country illegally as possible. They campaigned on it. That's what they planned to do. They were carrying out that edict. Now, the question is, well, how far can they go in a courthouse? Public areas? Can they go into the courtroom? Can they go just in the hallways? This is the center of this whole debate, really, and what this case, at its core, is really all about. And did Judge Hannah Dugan, was she following a policy which was not in place, but was at least in the draft form?
Draft.
The prosecution says, no, there was no policy. Our guys didn't do anything wrong. They followed whatever she asked them to do, but there was no official policy. And the defense is saying, well, there's no policy, but there was guidance from these earlier memos, and she was just doing what the draft policy advised her to do.
Go ahead.
Are we going to take a break? I just need to ask out loud because I couldn't hear. We're going to take a break in just a moment.
Same as you. I heard someone try to talk, but I...
a little bit late on our Ed Ted here. I think we're going to take a quick break. We'll check in with you. We'll be right back. Keep it right here on the Wisconsin Live Desk. We have so much more to come. Be right back.
defense is saying. All right, back. Judge on trial. 7 o'clock here on the Wisconsin Live Desk, streaming here on Fox Local. Mary Stoker-Smith, Brian Polson here. We're reading through notes from Bill Miston, who was at the federal courthouse. There is a question, a sticking point over a jury instruction. That jury instruction has to do with one of the counts, maybe even both of the counts, but one in particular that has to do with whether or not the defendant, Hannah Dugan, to obstruct this federal proceeding, had to know whose federal proceeding it was, the identity of the individual. Right now we have the lead attorney, First Assistant U.S. Attorney Richard Froling for the government, arguing back and forth with the defense team, Nicole Maznica, and Ted's got his hand up. But okay, Ted, tell me more about what's going on here. You've got your hand up.
Before you go down, and I'm not being flippant. I'm not being flippant here when I say this. This is a fascinating back and forth. You guys have it in front of it. It's almost like it's like a radio play. You two should go back and forth. Mary, you take Maznica.
Okay.
Brian, you take Froling.
We'll
I'll
pick it
play
up.
the judge.
Okay.
Yep.
Where do we start?
We'll do it verbatim. This is like radio on TV right here.
Do we want to start with Froling?
We
Let's just
desire
set
the
this up.
clarity.
Yes.
We desire clarity whether Dugan needed to know the identity of the subject of the pending proceeding. I am Richard Froling. The answer is no.
Yeah. And then I'm coming up with, how do you get to obstructing a pending proceeding if you don't know who it's for?
She doesn't have to know who the arrest warrant is for to obstruct it. The defense is proposing an extra element here. This is what the court settled on.
But this is not an additional element. It has to be specific that the defendant knew of the proceeding.
Knew of the proceeding, which is interesting.
The proceeding.
It's attempting to change the rules after the fact. And then, I guess you're Judge Adelman.
The judge. All right. Let me confer with my clerks. Well done, guys. I felt like you brought the courtroom to the viewers there. Good job. And I don't mean to be flipped there,
But this is
that's
what's
what
going
this
on
is,
in there right now.
Going back and forth.
This is
so
out
you
of
might
a
as well
movie.
have you two read the parts.
But they're
exactly.
going back and forth, and I do.
And we thought.
Go ahead.
We thought this question was settled about an hour. We thought this question was settled an hour ago. Clearly, it's not been settled.
But what I'm getting, Ted, and tell me if you agree with this, it seems like clearly they're not agreeing, the prosecution and the defense are not, on a key thing that's a sticking point for the jury. And Judge Adelman now has to decide, okay, who do I go with here? And how do I instruct this jury? His decision could very well sway what the jury does with this. And I do wonder, and this might be a good question when we bring in Jonathan Lavoie here in just a little bit from Kim and Lavoie, is does he err on the side of protecting the record for appeal? And that is siding with the defense so that the defendant doesn't have something to appeal on. On the other hand, I just don't know. I just think this is a really fascinating decision for Judge Adelman to have to make right here because it could make or break the case.
I think it's interesting, though, that Adelman is not siding with Froling, saying, listen, we decided on this. This is what the court decided on. Couldn't Adelman at this point say, true?
He could, or he could say, she makes a good point. That's already in the jury instruction, that the proceeding means the proceeding of a specific individual. The government is saying it just says knew of the proceeding.
It's so fascinating to me that this is just coming up now.
Right.
And kudos to the jurors for pointing it out.
I mean, someone in there is paying close attention to the specific words. But, you know, remember back in I hate to bring up past political things, but it just sticks in my mind. You go back to Bill Clinton and the Lewinsky scandal, and there was the whole meaning of the definition of the word is. What does the word is mean? And I won't go back into how that played out. But here, we now have a question of the word the. Does the proceeding mean just she knew there was a proceeding, or the specific proceeding of an identified individual? The word the
right
could be the key to this case.
The proceeding. Who was on this piece of paper?
Right.
And is it the same name on her call sheet, which was placed on her desk by her clerk, Alan Freed?
And the being Eduardo Flores Ruiz.
Flores Ruiz, yeah. And if she didn't know that the proceeding that they were there for was his, it does raise the question, then why was she sending him down the hallway? Why was she sending him out the back jury door if she didn't know it was him? But if the law says what it says, that's what the defense is saying is, well, the law says what it says, and there's no evidence here that she knew it was necessarily him. I just think this is really fascinating.
So here's what we don't know. We don't know how many people are curious about this. We don't know if it's 1. We don't know if it's 6. We don't know if it's 8. We also don't know where they are along the line of deliberating, whether once we get past this, we can vote, or once we get past this, we got a bunch of other questions. So
right.
obviously, only 12 people know what's going on in that room 2 floors above us. But it's fascinating to ponder where they are in the whole scheme of things, because they started here at about 2:30, let's say. So we are going on 4.5 hours. Is my math right about that?
I would suspect, Ted, though, if it was a whole slew of things and they were just taking them one at a time, that they might have said at 4 o'clock, forget pizza. Let's go home and come back tomorrow.
Yeah.
But if they knew it was one thing they were fighting over or trying to determine, then they might go, I think we can work this out. Let's get some pizza and stick it out.
Yeah. That's what I was going to ask Jonathan Lavoie when he joins us. Right. Go ahead, Ted.
I don't mean to be flippant about the meal thing, but they had a really early lunch because
No, they did. You're right.
The defense wrapped up in 45 minutes. And what they were going to do is have the prosecution start their closing arguments, then take a break, then have the defense come back, and then have the rebuttal from the government attorneys, which is, the standard way of doing it. And then the judge said, "No, that's not right. We can't do that. We got to keep them all together. Bing, bang, boom, instead of bing, lunch, bang, boom." So they had a really early lunch. So they might have just gotten hungry again, and they might be close. Again, it's all fun to speculate about how close they are or how far away they are. But again, 4.5 months, still safe. The record is still safe.
We hope it stays that way.
Anyway.
Mary, have you ever been on a jury?
Never. No.
Ted, have you been on a jury?
I have wanted my whole life to be on a jury, and I never get past the part where they call you down, and I don't know, for whatever reason, if I look like a guy who's going to ask too many questions in there and they say he's not worth the bother or what. But no, I've never been on, and would love to be on one. Just, A, it's your civic duty. It's like voting. You hope you get a chance to do it. And B, I would just love to see the inside, just from the experience of what it's like to be on.
Well, and that's why I bring it up, because I've never been on one either, but it feels like it's 12 human beings who have emotions and opinions and various life backgrounds and experiences who listen to the same set of facts over here 4 days, and they're in there right now just hashing it out. It's people trying to come to consensus. It really is one of the great American experiments that happens over and over again, but we don't get to see it.
Right.
We don't get to be in there with them. I think the drama that's going on in there right now is fascinating, especially when you know, as your civic duty, someone's potentially freedom and or someone's lifelong criminal record hangs in the balance.
Yeah. It's always interesting when you hear from jurors after a trial, what was the hang up? You heard from them. What did you feel was the overwhelming evidence to either convict or not convict? I always think that's fascinating. To hear from those people, because everybody comes in, Brian, to your point, with their own respectable baggage. So, it'll be interesting, too.
Sometimes we never hear from them, right? We never hear from them. The judge will say, after this is over, whether they acquit her, whether they convict her, the judge will say, you're free to go. You may or may not talk to members of the press. It's entirely up to you. Sometimes there have been cases where jurors have all said, none of us talk, right? We made our decision. Let's live in peace with it and move on. Sometimes there's 1 or 2 jurors that want to talk and explain what was going inside that room. So you never know one way or another until it's all over who's going to talk, who's going to want to talk. I mean, ideally, you'd love to talk to all 12 jurors, because I'm really curious to know this, guys. Are personal opinions about ICE in that jury room right now? I mean, they have to be in that jury room, but are they being openly expressed? Because the state was very clear. They said it in opening statements and closing arguments. This is not a political case. This isn't about Judge Hannah Dugan's opinion about ICE. It's her desire to take the law into her own hands. Whereas the defense is kind of saying, it is a little political. You had Tom Barrett as a character witness, as you pointed out, Brian, and also Jason Luzak in his closing arguments today. I'm looking for the exact quote, but it was something along the lines, ask yourself, how far up does this go? Who was making the decision to charge her vis-a-vis? Is it more than the U.S. attorneys, or is this some political pressure to charge this judge?
Well, Ted, in spite of Mary and I trying our poor attempt at theater, We want to
I
take
think it
this
worked.
really interesting
I
back
think
and
it
forth.
worked.
Okay, I want to take this really fascinating back and forth that's actually going on at the courthouse and bring in Jonathan Lavoie of Kim and Lavoie, a defense attorney and our legal expert throughout this week and throughout this trial. Jonathan, what do you make of this back and forth over this specific jury instruction? It's the second time the jury has asked a question about this specific thing, and there's a clear difference between the government and the defense over whether or not the proceeding means just she knew there was a proceeding or she knew it was this specific man's proceeding. How significant is that?
This is fascinating to me. I always love jury questions because you get sort of an insight as to what they're talking about or what they're arguing about. And this seems like a big issue to me because I'm not sure the government really established how Judge Dugan got to know that this is the individual that they had the warrant for. I think you guys were talking about it before. Was she just looking at people that looked generally Hispanic and having them leave the courtroom, or did she truly know that this was the actual individual they had the warrant for? And that's why the defense is pushing for that information to be in the jury instruction. And it appears to me that Judge Edelman, at least initially, said the defendant needed to know the identity of the subject of the warrant. And that's what I think he ultimately advised the jury on, but they're still confused about it. So this is good for the defense, and I can see why they're happy about that.
Well, and to your point, to underscore, the defense said that she never acted corruptly. She was doing her job as the judge, complying with the big D word, the draft policy. She was complying with this thing, the draft policy, and sent a man and his lawyer out of her courtroom. That seems to be a big sticking point, this whole draft thing.
Exactly right, because the jury's, if they felt that she was following orders or following a protocol, that gives her a lot more cover, right, than if she's acting rogue. And I think the jury is going to provide her a lot more forgiveness if they believe that she was appropriately following a draft policy, whether it was imposed or not. At least it was a policy that gave some guidance to these judges who were clearly confused and clearly seeking this information from the chief judge.
I can imagine people watching this, though, who think what she did was, we saw it, we can see what she did, it's blatant. They go, she clearly knew it was him, otherwise why'd she send him out the back door? But here's an interesting thing that did come up along the way. You had Eduardo Flores Ruiz, who does not speak English, his defense attorney, the public defender, Mercedes De La Rosa, saying, and we see in video these two other public defenders come and start saying, hey, there's ice down the hall, there's ice down the hall, and she goes back in the courtroom. She testifies that at some point she became, I think she used the word obnoxious. She herself became obnoxious about getting her case called early because she was nervous that ICE was in the building. Is it that maybe Judge Dugan had no idea who they were there for, but when this one attorney got nervous, she said, okay, let's get your guy out of here? That still may not seem very defensible to a lot of people. That still may seem like it's wrong, but it may not meet the definition of what is in this jury instruction. Do you think, I mean, am I making sense here?
Yes, you're making perfect sense, and that's exactly right. The jury is asking, does she need to know it's Mr. Flores, right? Does she need to know the guy? And that's what they're seeking, and that's what the information they want, and I think it might be a sticking point for the jury.
Because the natural question is, if she didn't know who it was for, why put him out the back door, unless it's his attorney now who's scared and she's just trying to help? Because the next thing she does is say, is there anyone else in here who looks, and her clerk had said, do we need to do the interpreter cases first? Like, let's get all of the people out of here who might not want to be in the hallway with ICE. That almost adds to the thought that maybe she didn't know which case they were there for.
Right,
After
so
4 days, it's a surprise to hear that.
She might be shepherding multiple people out of the court. And then the issue is, did she actually know this particular individual had a warrant? And that's what the jury wants to know. And the state never addressed that. And I don't think that was ever proven in court. You correct me if I'm wrong, but I'm not sure the state really addressed what did Judge Dugan ever know about Mr. Flores specifically in this warrant.
So does this come down to immigration policies, where they are saying that she has, quote, the defense saying the jurors have, quote, the ultimate check on government overreach and power? That's what they are deciding on. Does it come down to a case of that?
Yeah, I've said that now for a couple of days, and I really think that, everyone is talking about this not being a political event and that we shouldn't read any politics into it, but the jury can't help it. They're human beings. They absolutely come to the table with their own opinions. And we know how society is right now. Everyone has strong opinions about this issue. And the defense absolutely is bringing that up in their closing. And by calling Tom Barrett, they're not specifically saying politics, but they're inferring it. And they're hoping that there are members of this jury that are going to fight for that side of the coin. In other words, that the government is overreaching and that this is unfair to this poor judge, and that's the crux of their case.
Ted Perry was raising his hand. He's got a question or a comment here. Ted, what do you have on your mind?
Well, we got Jonathan, so I got 5 million questions, but I'll start with this one here. If Jonathan can hear me, he can hear me, right?
I can hear you. Yep.
Oh, perfect. Great, Jonathan. Thank you again for being with us. Really appreciate you guys, Kim and Lavoie, joining us all week long. I thought Judge Cervera gave a very vulnerable, honest testimony the other day for the prosecution and used words like embarrassed, uncomfortable, irritated. I have all the list right here, abandoned, shocked. Really came across as a sympathetic witness, in my opinion, but yet the defense kind of went after her and tried to discredit her in their closing arguments today. Two-part question. One, your thoughts on that, and two, and I'm serious about this, Jason Luzak will someday have a case in front of that judge again. What happens then? Because he pretty much said you can't trust her, you can't believe her.
Yeah, I'll take the first part of your question first. So it's clear the defense is trying to say that the government has basically either threatened Judge Cervera or intimated that they were going to drag her into this situation and she needed to pick a side. And that we can't rely upon her testimony because it's not reliable and she's testifying out of self-preservation. And I thought that was a valid point to make because she clearly was involved in this event. We couldn't hear what she said, but clearly she was involved, and now she's clearly trying to protect herself. As to the second part, judges routinely will recuse themselves when they have a relationship with a particular lawyer or litigant. That happens all the time. I have really good friends who are judges who, when I happen to have a case in their court, they just simply recuse themselves. I would anticipate Judge Cervera, if she saw Mr. Luzak show up on her calendar, she would probably just kindly recuse herself and they would assign a new judge. So that's a pretty common issue. I don't think he'll ever be in front of her.
You've never had to go after a judge who was on the witness stand in your career, have you? You've never been faced with that situation, which is
this is unprecedented for sure. Yeah, this is crazy. Yeah.
Yeah.
Well,
all right.
Guys, we're going to just give you a pause, take a drink of water, regroup. We still have a lot of questions, especially for you, Jonathan, if you were able to hang out with us for a little while longer. We appreciate your insight. We'll take a quick break and come right back as we await the jury deliberating here in the trial of Hannah Dugan. We'll be right back here on Fox Local.
All right, 7:21 p.m. Mary Stoker Smith, Brian Polson, judge on trial. Judge Hannah Dugan. The jury has been deliberating now, Mary, for 5 hours and 6 minutes.
Yeah, that's exactly it. And this all started 8 months ago to the date. So this has just, become a waiting game so far. Closing ceremonies, as Brian mentioned, 2:30 today. And there seems to be, and again, Jonathan, let's start with this. We are talking about one area that there have been a lot of questions on with this jury. Is the person referring to just a blanket statement, or is it Eduardo Flores Ruiz, or are there multiple issues? We could surmise, in your legal opinion, that there's one issue that this jury is hung up on, because if there were multiple, to Brian's point earlier, let's say there's 4 or 5 issues, would the jury likely have said at 4 or 5 o'clock today, you know what, we got a lot of things to sort out, let's break, let's go home for the day, start fresh tomorrow?
Well, my experience with juries is they prefer to stay late. They would much rather try to reach a verdict and not have to come back tomorrow. So it didn't surprise me that they wanted to eat dinner and see where they could go with that today. But it's clear that there's an issue here. We're at the 5-hour mark, and they've got certainly at least one issue that they're stressfully dealing with right now. It's complete conjecture to know if there are other issues as well, but we know that this jury instruction issue that we've been talking about is clearly important to them, as they asked about it twice.
Just to bring everyone up to speed, at 2:15 today, the jury began its deliberations. About an hour later, there was a knock on the jury door, but the court security officer said he didn't know what that was all about. They got nothing. 15 minutes later, another knock, and eventually all the parties came back into court. We found out there was a question about an exhibit that had to do with internal ICE protocols, internal ICE policy on steps to take when issuing a warrant. Then at 4:33 this afternoon, another knock on the door, and there was a question, a slip of paper. The jury had questions about this one jury instruction we're talking about now. Did Hannah Dugan need to know who the subject of the warrant was? And then at 6:35, they knocked again and said, we still need clarification on that point. Did she need to know the specific identification of who the warrant was for, or did she just need to know she was interfering with a government proceeding with a warrant and not necessarily have to know whose it was? That's where we are now at 7:23 tonight. Jonathan, I know you just said a minute ago that clearly the jury has an issue. Do you think this is the only issue? If they had others, would they have asked those questions? Or is there a chance that they're going to take this one first and then address the next one? What's your experience there?
My experience is they probably have a number of issues, but this is the one that they needed clarification on. They may have disagreements about other issues, but they might just not need the judge's input from it. So generally, juries have multiple questions about multiple things. And if they need to see a piece of evidence, or if they're unclear about a specific jury instruction, that's when they ask questions. So I would surmise that they probably are talking about a lot of different issues, but we know that this one issue is definitely one that bears consideration.
There was a question in my ear from one of our managers. Brian Graham asked me this, and I think it's actually a good question to know. If the concern here is, and the government and the defense are sort of arguing over what's actually in the jury instruction that the judge approved, and what the defense is saying is in the law, but may not be 100% clear in the jury instructions. The defense says it is, the government says it isn't. If it turns out there's something in the jury instruction that's incomplete or wrong or something, is this the kind of thing that could actually set up a mistrial, or is this just all still about what those 12 jurors decide?
I doubt that Judge Eagleman would mistry the case after he instructed the jury and made the decision to instruct the jury a certain way, but it could be an issue for appeal. Jury instructions are ripe for appeal because when the Court of Appeals looks at a trial court case, they want to make sure that the jury got the law correctly. And if they're informed incorrectly, that can be a basis to overturn a conviction.
They have to convict or not beyond a reasonable doubt. Could this come down to, listen, there is clearly some confusion over the actual arrests of illegal immigrants, because it could come down to, listen, this was a draft policy. Hannah Dugan wasn't doing anything wrong, as the defense pointed out, their words there. This all comes down to this uncertainty. Could this lie in that hand, if you will?
Absolutely, and that's where criminal defense attorneys live in the world of reasonable doubt. It's very rare that we have a case where a client has acted perfectly or there's nothing to explain. So oftentimes what we're asking juries to do is say there may be something here, but the state hasn't or the government hasn't proven the case to a certain level. And that might very well be the case here, where the juries might feel, or the jurors might feel, that Judge Dugan wasn't acting appropriately, but they might not reach that level of beyond a reasonable doubt to convict her, and that's what the defense is hoping for.
Ted, did you want to jump in with a question? You had your pen up, we saw.
I've learned to raise my hand because of the audio timing being a little bit off. Jonathan, I want to go back to yesterday and the government witnesses. Because it just dawned on me that we talked about the government and the prosecutors saying, this is not about politics, this is not about politics, this is not about politics, this is not what you think about ICE. And yet, they asked two questions of Alan Freed, the court clerk, and of Joan Butts, Dugan's court reporter. And they got Freed to admit that he called an ICE agent a fascist. So I guess we see where his politics are. And Joan Butts, when asked, ICE was here, what did you think? And she said, and I'm quoting here, it really pissed me off, showing where her politics are. So why did they introduce that and then come back in closing and say, but this isn't about politics?
Because it helped them. They obviously wanted to paint Judge Dugan's court as a anti-immigration court, and all the staff and Judge Dugan are sort of together in their beliefs. But I think it's a great point, Ted, that you can't really have both sides. The government can't bring out politics on what it helps them and then say you can't bring up politics when it hurts them. But politics is all around this case, and we can try so hard to try to avoid it, but it's just seeping in every part of this case. And I always said that the jury selection day was the most important day of this case, because you're going to have so many people that have unyielding opinions about immigration, and some people simply cannot be moved. And that's why I thought this case might result in a hung jury, where somebody might just simply hold out and just not come over to the other side.
Well, we don't know what's going to happen
Well, that
yet,
was going
but
to be my
obviously,
question.
Go ahead, Ted.
Yeah. So what happens, and because we don't know, none of us have a periscope into that room, if one of the jurors says, well, I don't like ICE, or another one says, I think they're doing a great job, do other jurors then jump in and say, hey, we're not supposed to be talking about this, but it's human nature to talk about it? So who's policing who in that room? Because there's no court supervisor, there's no, representative of the defense and the prosecution. It's just those 12 jurors. So how do you stop someone from bringing up something that they were told not to bring up? Or is it just a group mentality in there? What has your experience been with that, when they're told not to talk about something and yet somebody wants to talk about something?
Yeah, Ted, it is self-policing. The jury has to police themselves. But at the end of the day, if you have a juror or jurors that are being obstinate or are simply not changing their mind, and the other jurors think that they're inappropriate or making considerations out of inappropriate facts, that juror has the right to vote. And they can vote guilty or not guilty, and the other jurors can't stop them from doing it. And if it becomes hopelessly deadlocked, where the jurors simply cannot reach a 100% consensus, the judge at some point would have to call it a mistrial, and it would be a hung jury.
It is 7:30 right now on Thursday night, December 18th. The jury has been deliberating for more than 5 hours. I want to correct myself. It wasn't 2:15, it was 2:25 when they began, but we are still over the 5-hour mark. We're going to take a break. We'll be back with more here on our Wisconsin live stream right after this. Welcome back. It is 7:32 on Thursday evening, December 18th. I am now Brian Polson, back with Kim Murphy once again. We're just rotating everyone on this desk because it's been a long day.
Yes, and you have been here the entire day.
Well, we started at 9 o'clock this morning with the defense case, and before we even got onto our live stream at noon, they were long since done, and we were into closing arguments, and now we've been in jury deliberations for more than 5 hours. We have Ted Perry out at the federal courthouse. We have Jonathan Lavoie of Kim and Lavoie, a defense expert who's been joining us all week, and we're grateful for that. Ted, I know you said you've got another question for Jonathan. I see your hand up. I'm going to let you fire away right off the bat.
But before we do that, let's get that update from Bill Miston that just crossed in the last 15 seconds. Edelman is back on the bench, and here's what they're advancing. To know of the pending proceeding, the defendant needed to have sufficient knowledge about the nature of the proceeding. Froling says that's fine for them. Mazdika makes a record of their stance. What does that mean, Jonathan, making a record of their stance? Is this something for an appeal, perhaps?
That's just what you were talking about, Jonathan.
Exactly right. So if you have a ruling from a court and you disagree with it, you make your argument on the record, so then the Court of Appeals can review what you argued at the time and decide if the judge is wrong.
So needing to know of the pending proceeding seems very different from needing to know whose pending proceeding it was. That seems to be a decision, Jonathan, tell me if I'm right here, but that seems to be a decision that Judge Edelman has made that is favorable to the government here.
Absolutely. This is much different than what we saw before. So this would be much more general and would be much more favorable to the government.
Can either of you remind me of the makeup of the jurors? Who do we have? How many men?
7 men, 5 women.
Does that
7 men, 5 women.
Does that mean anything to you, Jonathan?
There was
You know, the gender in this case, I don't think makes much difference. I think the political ideology is 100% of the issue, and obviously gender doesn't make a difference to me.
But I'm very surprised, as I
Jonathan.
think all of us are, that this is going on. I mean, this is longer, the deliberations, than the closing arguments.
Well, that's true. But then again, I mean, it's not unusual for trials to have jury deliberations go on for several hours. I think if this gets into the days, then it gets really tricky. But I do think, Jonathan, tell me if this is true. If, to Kim's point, once it got past that first hour, you start going, they've got a hang up here. This isn't the slam dunk the government was probably hoping it was, right?
That's exactly right. As we talked about before, the longer this drags on, the more likelihood the jury is in a fight over multiple issues, and it might not ever be able to get to the bottom of it. Sometimes when juries can't agree on things, they come to the conclusion that that is in fact reasonable doubt, and that sometimes results in an acquittal. So the longer they are out, the better it is for the defendant. But as they keep changing these jury instructions, it seems like we're almost moving the goalpost here. This seems really strange to me that they can't get this jury instruction right. So I think this is going to be a big issue, even potentially on appeal.
Ted, I think you had another question.
Yeah. Jonathan, take us through what it's like to be an attorney waiting for this. What's the longest you've had to wait? How do you bide your time? Where do you go? It's got to be the thing on your mind. You can't go. I mean, you can't distract yourself. Are they watching the Rams-Seahawks game? I don't know. What are they doing? Because I know a lot of people in here are. That's why I bring that up as an example. Well, what do you do as a attorney in that time? What is it like for you to be waiting this out?
Yeah, so Ted, when you try a big case, I mean, you spend weeks, if not months, preparing and putting every ounce of your being into it. So once you finish with the case, it's a relief. And then you go out, you maybe drink some water, relax a little bit. But after a few hours start going by, you start getting this nervous feeling because you know the stakes for your client. And it becomes worse and worse as those hours drag on. And the worst feeling and the best feeling, sort of both at the same time, is when the jury has reached a verdict and they're coming back into the courtroom. And you know that somebody's life is about to change and this verdict is significant. And it's a feeling that you can't get anywhere else.
Jonathan, just to that point,
and what do you do as an attorney when they're coming back? When they're coming back, you as an attorney, do you make eye contact with them? Do you look? Do you study it up? Do you try to read the tea leaves, or you just go, I'll know soon enough?
Ted, I look every time, and I can almost always tell based on their face. If they're looking really they look really somber and look down, I can tell that my client's getting convicted. And if they're a little bit more lighthearted, they're getting acquitted.
I wonder, Jonathan, for you, though, when you're sitting in this point, you know it's in the jury's hands, and no matter how much you look back at the evidence, no matter how much you look back at the facts, there's nothing else you can do. Do you start second-guessing, going, we really should have called that other witness, or I really should have asked this extra question? Do you do that game, or do you try not to? Do you try to think about other things?
That is all I do. You are exactly right. When you sit back and look at your trial, you're like, man, I should have done that. I could have done that. And then you have family members of your client coming up to you saying, you should have asked that question. And so you second guess yourself and you doubt yourself all the time. And once the jury verdict comes back, there's a little bit of a relief because at least you know where it's at. But during that deliberation period, I can tell you all the lawyers in this case right now are biting their nails and second guessing themselves and wishing they would have done something. And you get like a jury question, you're like, why didn't I think of that? And why didn't I focus on that issue during the trial? So there is nothing but second guessing happening right now.
I mean, perhaps is the government right here going, gosh, we had it. We could have proven that she knew exactly who it was, but we didn't think that was even going to be an issue. That might the kind of thing you're saying that you go, if I'd only known that was going to be the question.
Exactly right. And that happens a lot with jury questions because there are some times where I'll argue a case and I'll talk to a jury afterwards and they were focused on something that I wasn't even thinking about. And they're on another topic that I never really addressed. And I'm like, why didn't I address that? You just never know what's important to a jury. When you get 12 random citizens into a room, you just don't know what's important to them.
So, Jonathan, to review those who are just joining us here on Fox Local, what seems to be the question for the jury right now is, did Hannah Dugan know who the ICE agents were there for? Did she know the name that was on the warrant?
That's right. And I think we all agree that the government did not really provide evidence to support how or if she knew that he was the actual individual. So again, if the state bears the burden of proof, and that's clearly an issue that the jury is concerned about, and that's why they're asking Judge Edelman, did she need to know the identity of Mr. Flores or not? So, boy, that's a big issue right now, and I know that that's why the attorneys are fighting so hard to try to get the judge to instruct the jury a certain way.
I think I'm hearing in my ear that, Jonathan Lavoie, we're going to have to cut you loose here soon because you have a really important appointment. You've got to get from where you are now to the Fox 6 studio so you can be here at 9 o'clock. So we need to let you go to that very important appointment. We don't want to hold you up. But thank you, Jonathan, for being here.
Soon. I'll be down.
See ya. Thank you, Jonathan.
Thank you for being here on this live stream. Ted, you have been sitting. Yeah.
Tell Jonathan he can use my desk because apparently I'm not going to see it for 4 months.
Well, you've created your own desk there, and I just want to ask this, Ted, because earlier today when it was 48 degrees, you said the heat wasn't even on, so you couldn't melt your sandwich again today. But I've been listening ever since then, and there's this sound. You can tell the heater's back on now that it's 20-something degrees outside.
The heater is back on. It's toasty. Christina Van Zels is upset that she wore a sweater to cover this case today. She's complaining about how hot it is, and I don't blame her. Now it's cooled down again, but it is not. This is an old building, man. It was built, they first started building this thing back in 1892. It took them 7 years to finish, and then there were add-ons in the 1940s. It's a stunning, stunning building that we can't show you pictures of, anything. There's a beautiful Christmas tree display in the center of the atrium. I asked if I could just take a picture of it and was told, no, we don't allow pictures of any type. So, we're following the rules. But do yourself a favor, get down here sometime and look around. It's open on Doors Open. It's open on naturalization days. It's open when there's court. I had a gentleman come in, sit next to me today when I was in the courtroom, and he explained how he's been watching our coverage, and he was just fascinated by the whole thing. He had a doctor's appointment. He's a retired guy. He decided to come in and sit down, and then he said, I got a golf lesson at 11. I'm canceling it because this is so fascinating to me. This is, what America does. And so treat yourself and go. I know it sounds incredibly boring when you have the minutia of things at times, and the testimony can drag on and on and on. But just to watch the whole thing is a real privilege, and it's fascinating
You
to
know,
watch.
Ted, just
and
to
in
your
this building in particular, yeah.
Just to your description of coming down and seeing this, Judge Edelman knows how beautiful that courtroom is, to the point that there was going to be this audio testimony that wasn't really easy to hear, and they know the acoustics are not great in there, but Judge Edelman said, no, we're having it right here. This is the best courtroom in the state of Wisconsin. We haven't seen it because we can't see it, but certainly something you've seen firsthand.
So I want to jump in here because I'm very curious about just going back to Hannah Dugan's defense team, and now, you know, given that we are at this late hour, their strategy would appear to be brilliant, that she didn't testify in her own defense, and that former Mayor Tom Barrett did testify, and that it maybe insinuated a little bit of politics in this. So I was Googling, and Hannah Dugan, there is a legal defense fund that has been established for her. And I don't know if these are real-time donations that are popping up, but I am seeing donations of $25 coming from Columbia, from Madison, Wisconsin. So again, that's to this having a wider implication than what happened in Milwaukee. Another person, Dallas, just donated $25. So it's very interesting that this is going on as the jury is deliberating.
We have to hear from the people who pay us, so we do have to take a break here. We've got more coverage to come from the Wisconsin Live Desk. Kim Murphy, Brian Paulson, Ted Perry. We got more coming up right after this.
Welcome back to our extended coverage of the Hannah Dugan trial. We are on verdict watch.
And have been now for 5 hours and 21 minutes. It was 2:25 this afternoon when the jury of 7 men and 5 women left the courtroom and went in to begin their deliberations. They remained there. They have knocked on the jury door 5 times. Twice it really turned out to be nothing, but 3 of those times, once they asked a question about an exhibit. It was exhibit number 7, which we know from the discussion after that it had to do with an ICE internal policy that had to do with what their steps are that they take when they issue an administrative warrant. At 4:33 this afternoon, they asked their first question about a jury instruction, specifically whether or not Hannah Dugan, to meet the elements of the crime, had to know not just that there was an administrative warrant or a proceeding, but whose warrant it was. They then came back 2 hours later and asked for further clarification on that. Ultimately, after some disagreement between the government and the defense attorneys over how that should be instructed to the jury, Judge Edelman said he would instruct them, and I want to read the words exactly. They said, Judge Edelman came back and said, this is what they were telling the jury. To know of the pending proceeding, the defendant needed to have sufficient knowledge about the nature of the proceeding, but it doesn't say anything about knowing whose proceeding it was. Jonathan Lavoie just told us moments ago that was a very favorable decision for the government, not for the defense. But
It's
the defense made a record of it, meaning that might be an issue on appeal.
Of the things that we were discussing earlier, that's not what I thought that the jury would take more time on. I thought that they would spend more time discussing whether the fact that Flores Ruiz did not take the stairs, that he ended up back in a public hallway and he was arrested, and that maybe they might say, well, he got away. I mean, he didn't get away. He was arrested, so no harm, no foul.
And I do think the state, or the government, I keep saying this, I'm so used to covering state court. The government made that an issue very early on.
Yeah.
And that was that right off the bat, they said, it doesn't matter that he didn't go down the stairs. It doesn't matter that he got caught. What matters is she did something that was attempting to conceal him. And that seems to have not been the thing. At least we don't know. They could still be hung up on that too.
Right.
We don't really know. We've got Jason Calvi, who is live outside the federal courthouse. Jason, all week long you've been in the comforts and confines of the 6th floor of the Milwaukee County Courthouse. Now you're out in the elements outside the federal courthouse. A little bit of a different environment for you this time, yeah?
Yeah, and I was wondering if Ted was still on because I had a question about him. He's such a history buff.
Oh, he's
is
there.
Ted on the line?
Yeah,
he
he's
is,
there.
yes.
Hey,
I'm here.
Hey,
Bring
Ted,
it
can you
on.
hear
Bring
me?
it on. Bring it on.
hey, Ted, quick
Yeah, you
history
bet.
question. I'm in front of the beautiful federal building here in Milwaukee, and there's kind of some twins for this building. Do you know in particular where some of the other buildings that look almost identical to this one are?
Peoria, Illinois? Is that the right answer?
I'm not sure about the Peoria.
I'm gonna
I know
say
there's
Peoria.
one else in the Midwest, but there is maybe Peoria. But the one that I'm thinking about is the old post office building in Washington D.C., which very much looks like a twin of this building. It's maybe a little bit more elaborate, but if you look at that, it's now became the Trump International Hotel in Washington D.C. But if you look at the exterior of that, you're going to see it looks very similar to this one.
Okay.
It was designed, I believe, by the same architect. So definitely had a vision for this.
I believe
is
you're
it called neo-Romanesque?
believe-
Is that what it is?
Yeah, something along those lines. And it makes sense because
Yeah,
this was a post office. The first floor was a post office
Yeah.
back in the day. Now you can still send mail here, but you have to go down in the basement to do it. But granite from the great state of Maine, Mount Waldo granite from Frankfort, Maine. You're exactly right. Romanesque leaf ornament, and occasionally with faces and gargoyles. I mean, it's just a
Listen,
stellar
here's the
business.
thing. What you're saying,
And
Ted,
guys,
is
get
this
this,
is a
get this.
beautiful building. You shouldn't take it for granted. My last dad joke, I swear, it's my last one. It's my last
I'm a
one.
little
Back
slow
to
on
you,
that.
Ted.
We're all a little punchy
That
there.
was a great dad joke. That was
that
awesome.
was pretty good. That was pretty good. I think I was part of a setup unintentionally. Guess what the cost was of construction when it was completed?
$2,000.
1897.
What year?
1900, let's say. Total cost of construction,
$550,000.
1.4 million.
Oh, wow.
Yeah.
I was way
Yeah.
under. I said 2,000.
Okay.
You'd have a shack.
And in
eh?
today's dollars, that would be a lot more. Let's just say it would be a lot more.
A heck of a lot more, yeah. But it's actually gorgeous. And all right, fine. You want to do trivia? Let's do trivia. While we're kicking time. You want to do it?
Sure,
You want,
I feel like
Jason?
right
I'll get
now
one
this
right
is
back at you.
Euchre. You are Bob Euchre killing time and when there's a rain delay and extra innings. So anyway,
That's fine.
Do we know
I'm honored by
do we
the
know what kind of
analogy.
pizza they got?
Oh, you always have to have a
No, we don't.
vegetarian
We don't.
option, all cheese, right?
Yeah, I'm thinking if there's a smart juror, they've ordered pineapple and Hawaiian, because that is a pizza, and I don't want to hear otherwise. In Judge Edelman's courtroom, there is the seal of the city of Milwaukee carved in wood, and the great seal of the state of Wisconsin. Can you picture it? It has the badger, it says forward, it has the cornucopia, and there are two human figures on that seal. What industries do those two human figures represent? No cheating.
Farming.
No cheating.
Is there
Logging. Logging is the first. First is logging, and the second is mining, which is why we are the
Final
Badger
answers,
State.
please.
We got it from
Okay.
Jason. Jason knows what he's
Mining is
talking about.
correct. Kind of halfway. Mining and
Okay.
sailing. And
Sailing.
you know, there's a sailor. So that represents the Great Lakes and the industry on the Great Lakes, and the miner. So you're right about that. And when you say where are the farmers? The farmers are represented in the cornucopia of food that is right at the bottom of the seal.
I was going to start
I
singing
stared a
some
lot at that
Christopher
today
Cross, but then
during-
we'd have to pay some sort of musical rights, so I won't do that.
Question, do we know if Judge
Yeah, I'm not talking
Dugan-
about a guy in topsiders.
Hey,
Huh?
a question, do we know where Judge Dugan is?
Yeah.
Is she still there? Did she leave for the evening to take a break?
Well, they don't go far. You know, it's the where are Frank Gimbel's attorney? It's Frank Gimbel's law firm. Gimbel, Guerin, Riley, and Brown, right? How do you know where they are? Anyone downtown here? No, we're all looking around at each other.
I've been
I imagine
there,
they're
but
there.
I can't recall.
Is it downtown, Jason?
It is. It's on Kilbourne.
Oh, it's on the one
Yeah,
Kilbourne? Okay,
it's
so
downtown. I believe it's across
I'm
the street from
guessing-
Milwaukee City Hall, if I remember correctly. No?
Okay.
Maybe I'm
Yeah, so not far away.
330
The one
East
attorney
Kilbourne.
that has been-
They're right there.
Okay, yeah, so they're not terribly far. My guess is they're there, or maybe went to dinner somewhere nearby. That's just a guess at my part. I have not seen her. We have no record of anyone capturing her leaving the building, right? So that is something, because we have, there's a pool camera, and all the local affiliates are, you know, banding together to make sure we get that shot, and we kind of share it if we have her coming into court or coming out of court, because, you know, we're kind of desperate for video because we're not allowed to shoot inside. So I'm guessing she's
Somewhere near.
over at the law offices of her attorneys. That's my guess. I have no reason to know that for sure.
Jason,
got-
I want to ask you, Jason, because we see you standing outside the courthouse, and I think we might have thought all week there was the possibility of there being all sorts of demonstrators outside. A lot of times when there's something high profile, there are, but we really haven't seen that today. And Jason, I don't see anyone really out there behind you. Is that I can only see the frame within which you are, but I don't think we're seeing any demonstrators outside. Is that right?
Yeah. Permission to turn my back to the camera?
Sure.
Okay, just 1 second. Yeah, I don't see anybody out there. The sidewalk looks completely empty. The snow is melting. I can see into the media room where Ted is talking to us right now. I can see some media members in that media
It's
room,
okay,
but
you
that's
can
about
wave
it.
at him.
There were protesters here on Monday. That was the first day of the trial, and then there was also a prayer vigil on Thursday, which was the night of, or the day of jury selection. So those 2 days we had people, there were people out here on the streets here in Milwaukee sharing their thoughts, but the rest of the week's been pretty quiet.
All right, we've got folks who are watching us here on our Fox Local app, but also on YouTube. And so one of the questions that came in is, why have we only spoken with a criminal defense attorney? We are going to speak with a former prosecutor, James Santel. He was the prosecutor
And
for
we've
the
had him
Eastern
on all
District
week, yeah.
of Wisconsin.
We've done both.
Right. So maybe
Yeah.
not in the time frame that a viewer was watching, but we have been very mindful to have both some insights from a prosecutor and also from a defense attorney.
And actually, James Santel, former U.S. attorney, so he's very familiar with all the parties in this case, not just the government lawyers, but also it happens to be the lead defense lawyer because he was also a U.S. attorney himself, and Stephen Biskupik. And I still find it fascinating, Ted, that we're talking about, and Jason, that the entire government team, Richard Froling, Kelly Brown Watzke, Keith Alexander, were all appointed by the guy on the other side, Stephen Biskupik, when he was U.S. attorney.
Yeah.
I know you
And
guys love
you
the
saw
sports
that
metaphors.
today.
You've been using them all week. Yeah, it's like the coaching tree, right? You know, all these guys came from Belichick, and now they're going against Belichick.
That's right.
Just another metaphor
I'm
for you. Go
hearing in
ahead,
my
Jason.
ear-
You know,
Sorry.
I love nothing
Yeah.
more than when guys go into sports analogies.
I'm hearing in my ear that
So you got anything else?
the coaching staff is in my ear saying we need to take a break. So we are going to take another commercial break. We'll continue with our coverage of the
We're on to Cincinnati.
Hannah Dugan jury deliberations, which are now 5.5 hours old. More here right after this. Welcome back. It is just before 8 o'clock, 7:59 p.m. here on our Fox 6 live stream. I am Brian Polson here with Fox 6 anchor Kim Murphy. We've got Ted Perry, who's out at the federal courthouse. And just a little bit ago, Ted, Jason had asked you the question about other courthouses that look like the Milwaukee federal courthouse. And one of our viewers, or commenters on the YouTube channel said, check out the old federal building in Augusta, Maine. And sure enough, I've got a picture of that. I don't know if you guys could take
wow.
Control could take my laptop right now, but yeah, that's the one. That's just like it right there.
Very close.
So that's the old federal building in Augusta, Maine. Looks a lot like our federal courthouse here in Milwaukee. Anyways, we hit 8 o'clock here tonight. We are now at 5 hours and 35 minutes since the deliberations began in the Hannah Dugan trial. This is a federal criminal trial where Judge Dugan, Milwaukee County Circuit Judge, is charged with helping a man who was in the country illegally to escape ICE agents at the courthouse.
She faces two charges. One is a felony and one is a misdemeanor.
Yeah.
So we're not quite sure which or both of those charges that the jurors are having some trouble.
There's one in particular, and I've got to look back at which one it is, but one that has the term pending proceeding, and I believe that is count 2, and I believe that is this more serious charge, the felony charge, but I'll have to double check that, or if someone knows and they can get in my ear and tell me, but I believe that's the case, and that seems to be the one where the jury hang-up is, but that doesn't mean it's their only hang-up right now. And as we talked to Jonathan Lavoie earlier, he said it may well be that they have multiple, but this is the one that they needed sort of the judge's assistance with.
We know when we're covering state trials, it's sometimes is a good sign. The longer the jury deliberates, it's in the favor sometimes of the
defendant. Yeah.
I don't know.
Well, Jonathan Lavoie, again, from the perspective of a defense attorney, he said he thinks the longer this goes on, the better that looks for the defense. But let's talk to someone who knows the other side, and that is former U.S. Attorney Jim Santel, who joins us here now once again here on our Fox 6 live stream. First of all, thank you once again for being here. You spent a lot of time with us this week, and you've been very gracious with your time. But I am curious, when we talk about that issue, 5 hours and something minutes, the jury's asking a lot of questions. Is that something generally that makes the prosecution a little nervous? Do you start to lose confidence, or is it hard to say?
I think it's hard to say in the end, Brian and Kim. I think that the issue here, of course, is you've got a conscientious jury. And I say that for two reasons. One is early on, what did they want? They wanted pizza, right? And so that signaled to me that this is a group that's going to stay here over dinner. They could have gone home, could have told the judge, listen, we're going to come back tomorrow morning. They've obviously followed up on their intention to stay. And they're also, again, they're asking for information based upon the trial. They made this request early on for materials or information related to the ICE policy. And now, as you have been talking, they're focusing, again, upon some specific language here, and they're plainly having some deliberation. It is difficult. I think it's impossible, as I said before, even with the verdict, to predict exactly what's going on inside that jury room. The takeaway at this point would be a very conscientious jury that is going through things with a fine-tooth comb, and that's what you want juries to do. This is not a jury that went back there, voted quickly, and said, well, we're all in the same agreement here, let's go back and return a verdict. I think they're taking Judge Edelman's jury instructions seriously, going through the particular elements of the offense, coming up with these questions. They're asking for clarification from the judge about what these terms mean, and that too means that they are focused on getting a good result, and a right result, I should say, based upon their deliberations. I think it's still much too early to predict, but certainly, yes, that's the common sense out there, that the longer a jury goes, the more difficulty they may be having in reaching a verdict at all, and frankly, even reaching a verdict in favor of the government. But again, that's not to say that they're not simply a meticulously focused jury at this point.
Do you believe that politics right now are at play, given that it's taken so much time? Because there weren't a lot of witnesses, there weren't a lot of pieces of, evidence for them to consider. So, what else is at work here? Or is there something else at work?
And again, we can't say for sure. We know that the judge has told them that politics should not be a part of this. And this is where we look to the foreperson, right, who's got these instructions from the judge. And if someone says, well, gee, I'd like to talk about the president's policies on immigration or enforcement or those issues, it's up to the foreperson and perhaps other members of the jury to say, you know what? Those are interesting issues. We have been told to focus upon what happened inside this courtroom. Let's redirect it to that. I have great faith, not only in grand juries, but also in juries. Grand juries, again, the ones who indict. Juries are the ones who determine ultimate decisions in cases, guilty or not guilty. My strong sense has always been that they are attentive, they have integrity, they take their jobs very seriously. These 12 people also know that they are, again, not going to be revealed, but the work that they're doing is going to be making national, indeed international headlines. And so that may be the other reason why they're focused on this. I would not necessarily read into this that somehow they've gotten diverted into fights or disagreements or even discussions about politics and immigration issues. I think that even after 4 days, there is a lot to chew on here. That includes, obviously, the agents on the first day. We've had 4 different judges appear. We've got the chief judge. We've got 3 other circuit court judges. There's a lot of testimony there. Maybe they're talking about Ambassador Barrett's testimony earlier today when he talked about the quality of this particular human being. Maybe they're looking again at some of the geography as we talked. Maybe they're trying to figure out, again, as we have chatted, about what the intent was. And that's the big issue. That's the big thing that I think they're wrestling with. And frankly, even some of the question they've gone back to the judge now on, suggests to me that they're wrestling with, again, her knowledge, this issue about whether or not she knew specifically that this was the defendant previously in her courtroom, or was it a more generic type understanding of what she was doing? That too reflects to me that you have got thoughtful deliberation going on. And I think even after 5 hours here, which is a long day for them, remember, they started almost 12 hours ago here. And I think that they are conscientious. And at some point, if they do not reach a verdict tonight, obviously they'll let the judge know that. But at least for now, that conscientiousness, I think, is still driving their conversation.
Jim, let me ask this, because we're talking about two charges here. There are two. Count one is, I want to make sure I get these in the right order. Count one, concealing from administrative arrest. Count two, endeavoring to obstruct proceedings. And count two is the one that has the instruction that number two, the defendant knew of the pending proceeding. That seems to be where the sticking point is, that the defendant knew of the pending proceeding. Did Hannah Dugan know there was this pending federal proceeding? And we just had Judge Edelman rule that what we're going to send back, what we're going to instruct them is they needed to know of it, and that they needed essentially know that the nature of that proceeding was what it was. They didn't necessarily need to know whose proceeding it was. And when we were talking to defense attorney Jonathan Lavoie, he said, that's a ruling that seems favorable to the government here. And we see Nicole Masnica saying, when asked about it, Froling says, that's fine with us. And she says, we're going to make a record of our stance. That sounds like the defense wasn't really happy with that instruction.
Exactly. And so the reason why you've got those differing views is the more specificity, the more particular aspects of the case that the jury has to find. Again, if the judge had told them, yes, indeed, you need to find it was this particular defendant, then that's something that's on the burden of the government to show and to prove. Rick Froling and his co-counsel said, no, it's much more general. You got it just right in terms of the sort of generic understanding of what Judge Dugan had to know if you find her guilty in the end. It definitely goes in favor of the defense. And again, for that reason, it is interesting to talk about and speculate, I suppose, on how that plays out when it goes back.
Just to clarify, jury. I'm sorry, Jim, not to interrupt. You said in favor of the defense. I think you meant in favor.
I'm sorry, in favor of the
government.
prosecution. Yes, absolutely.
We asked Jonathan about this earlier, but you have certainly had plenty of cases where you've been sitting around waiting for a jury. From your perspective as a prosecutor, what is that like as time goes on? Are you second guessing the witnesses you called, the questions you asked? Or are you trying to distract yourself and do something entirely different? What do you do as you're waiting? Because you have to stay close. You can't go back home.
You do.
Yeah, so what's that like?
All the prosecutors are in that building right now, and they're on the 5th floor. This is on the 3rd floor. For what it's worth, Kim and Brian, I just came from a bar meeting in downtown Milwaukee. I decided to be a bit of a reporter, so I happened to drive by the federal courthouse, looked up on the 3rd floor. All the lights are on, which means the jury is there. The lights are in the courtroom and so forth. So they're there. Your reporting is spot on in terms of what's going on there. But that's exactly right. You go back to your office. What I always did was work on other matters, work on other things. You're sitting there. The notion that you are simply you can sit around and talk to your colleagues about things and have perhaps less serious conversations about where you're going for the holidays and what you're going to be having for lunch tomorrow. But again, when it goes on several hours like this, at some point you say, okay, I've got a brief due next week, and maybe begin to work on that just to use the time wisely. Undeniably, everyone's focus is on what's going on in that jury deliberation room right now. The defense counsel also right down the street, as we talked earlier today, need to be within, frankly, 15, 20 minutes of the courthouse, and they will be. Judge Dugan is someplace in the downtown area right now as well, so that if indeed there's a verdict, all those parties will convene fairly promptly, obviously report on that, but they're all right now in the approximate area and doing various things while they're anticipating a verdict, maybe tonight, maybe not until tomorrow morning. We'll see how the night plays out.
I can't imagine. I mean, if the jury does retire for the evening and then you go home, that's even more time to think and maybe change your position. So that could extend the deliberations, I'm thinking.
It certainly could. It adds another element, which is time. I had a hearing just this morning that was sort of bifurcated. Even when you separate presentations to the court, you have to kind of go back and reconfigure and put things in place again. And so again, here it is, 8/11 on the very night of the beginning of the jury deliberation. I don't believe, based upon your reporting, there's any indication yet this jury is going home. And in part, it may well be just that, Kim, that they're saying, well, maybe we're close. Maybe we've got some instruction now from the judge on this knowledge issue. Maybe we can talk through that more. And if that's the last thing that we need to deliberate on, maybe they're saying we're within an hour or maybe 90 minutes of doing that. The evening is getting late, however, and that's the other point that I think you're making and your viewers are certainly wondering about too. They've had a long day. They've had 4 witnesses. They've had closing arguments here, instructions by the judge. Now we've got hours of deliberation. At some point, too, especially if the foreperson decides that the conversation is not as productive, it's perhaps devolving in some ways, she or he may also say, you know what, folks, let's put our pencils right where we are. Let's mark where we are. Let's pick up tomorrow morning and get some new steam, some new energy. This is getting a bit long, and at some point, again, I think the foreperson, maybe even the judge, subtly suggests that, you know, if we're here at 10 o'clock, 11 o'clock at night, maybe it's time to go home and start again in the morning.
Ted Perry is patiently in the back of the classroom trying to get the teacher's attention, and the teacher hasn't seen his hand. But no, the teacher saw your hand, Ted. I know you've got a question. What do you have here for Jim Santel?
I got a number of questions, and let me start with James, who's talking about waiting. Just out of curiosity, what's the longest you waited, and how did it go for you?
Waited several days, actually. That's not unusual. Again, we have some trials, obviously. I think the longest I had was 2 or 3 weeks or so. When there's, as Kim, as you were just saying, there's a huge amount of information for the jury to digest. That's not unusual, and especially in a white-collar case where you've got lots of documents. So again, the timing does mean something based upon the length of the trial. But again, I don't put a huge amount of stock in that. The result there was we got a conviction. And again, I look to that and I say, okay, again, as I've said before, never celebrate that. There's nothing about this as anything other than human tragedy. We are not joyful about that, but it comes in the wake of a lot of work for defense counsel, for prosecution. And when that jury verdict is returned, there is often an acknowledgement of, even among the attorneys across the board, of jobs effectively done. And I think they will say that here as well.
So I have a logistics question to follow up on that. If I can, guys, a logistics question. This is not like a Milwaukee County Court case where people might be from Shorewood or Whitefish Bay or South Milwaukee and they can all go home. These jurors are from 12 different counties. James, what stipulations or what accommodations have they made? Because this jury's not been sequestered, I don't believe.
It is not, and that's the other very important part about timing, Ted. You've focused on, I think this is very important. If you've got jurors in that room, still with the lights on, still arguing about things, discussing things, and 2, 3, 4, 5, 6 of them say, you know what, I know where my car is. I've got an hour and 10-minute drive home, even with the traffic not being all that much on I-94 and 43 other places to go, north, south. That can also be a bit of a consideration here, and at some point that can also be significant. If in fact, if judges sequester, then the government will put them up in a hotel. I don't think they're near to that proposition, that possibility yet.
All right, I am hearing once again that we've got to take another quick commercial break. Jim, if you can hang around with us, Ted, I know you'll be there as well. We will take another break here on our Fox 6 live stream, 8:15, and we'll be back in 2 minutes.
Yeah.
All right. Welcome back, 8:17, 8:18. We're about 7 minutes away from this being 6 hours of deliberations. And as you pointed out, it was 45 minutes of a defense case today, 4 witnesses. So this is quite a deliberation considering how quickly things were going earlier today. Brian Polson here with Fox 6 anchor Kim Murphy. We have Ted Perry out at the federal courthouse, and we still have people all over the place. The number one question everyone's asking is, are you still cool to hang out? We've been working a long day.
Yeah.
Everyone's hanging out. Everyone's staying.
The jurors.
This is our job, is to be here for you. The
Yes.
jurors are working. So if this comes down tonight, we're going to be here to tell you all about it. Until then, we just kind of keep you up to speed. And one of the people who has graciously agreed to stay with us is former U.S. Attorney Jim Santel. Jim, as we were talking before the break, this is something you've seen many times before. It's kind of old hat for you to wait. 6 hours is probably nothing. This is nothing to you. But when you're Hannah Dugan right now, and she's obviously presided over many trials where she didn't have this kind of skin in the game. But when you suddenly are the defendant, how different is that to wait and just not know what's going to happen?
I think that's an incredibly important point for all of your viewers to understand, Brian. And that is, again, my view about all of this is that it is human tragedy, right? Anytime there is a criminal prosecution of any kind, we're talking about something that's not only not happy, it is an absolute necessity for the purpose of security and safety of our community, enforcing the rule of law, justice, administration of it, all those kinds of things. But this is also about human beings, and prosecutors should never forget that. Defense counsel, never forget that. You've got a human being here. This is not about a larger political issue, or at least it shouldn't be, because right now the jury is deciding on the fate of the most significant thing that a government can do to any individual, and that is charge a person with a felony count and a misdemeanor count with the possibility of depriving you of your liberty. Now, highly unlikely here, if there was a conviction, that Judge Edelman would sentence Judge Dugan to any time in prison. But the comment about the significance of this cannot be overstated. Hannah Dugan, human being, Hannah Dugan, judge, is certainly very much aware of that. And this is a time of anxiety, right? It's a time of anxiety for her, for everyone to greater and lesser degrees in this criminal justice system. The stakes are significant, and she knows that. All the parties know that, because of the seriousness of criminal prosecution in and of itself. As I said, this most significant thing that a government can do, potentially depriving you of your liberty. That is at the top of the list, and so everyone is very mindful of that tonight.
In the government's rebuttal, they said, at the very end, the defense tried to raise distractions, and the jury was advised that they should not fall for any of that. It doesn't matter that there was a draft policy, that it was never in place, that is not what is the issue here.
Right, and so that's Rick Froling. And again, the lead prosecution attorney, along with Keith Alexander and Kelly Waska. You've heard a lot from all of them doing the opening statements, the closing, the rebuttal. And this is Rick's very appropriate response to the defense closing argument, identifying 4, 5, 6 different things and offering to the jury that when they go back into that jury deliberation room just adjacent to the courtroom where they've spent the last 4 days, if they're identifying these issues raised by the defense, yes, indeed, they should take a look at them. They should examine them. Rick is appropriately offering on behalf of the government how they should resolve those issues. As you just said, Kim, most of them indicating that they're not the kinds of things that should stand in the way, from the government's perspective, of your finding this defendant guilty. A very routine a rebuttal argument in the sense of what you need to accomplish in a rebuttal argument, plainly anything but routine in terms of the stakes here. And again, this extraordinary thing going on in the history of America, the history of the Eastern District of Wisconsin, the history of the world, arguably, where you've got judges coming in to testify, presided over by a federal judge, and a judge is on trial for conduct that, again, according to the defense, was a part of her regular proceedings. And again, 10th Amendment issues, those kinds of things. this is the kind of thing that, again, lawyers, law students, and I would say even historians should be looking at for years and years, and perhaps, and they plainly will be doing. There are going to be an awful lot of blogs, an awful lot of opinion pieces about this, regardless of the result. This is also one for the history books, and it's happening right here in our area.
It's going to be like Law 361,
Right.
the Dugan trial. It's going to be a whole semester, right,
And
at Marquette
James,
University.
Just
right?
another thing that Froling said, again, I'm just, going over some of the final statements. He says the moment Flores Ruiz went through that door into a non-public hallway, that's when Dugan concealed him. And for a lot of people, that's what they're thinking. That's what the thought that they had. The public, a lot of the public says, I saw it. He was in a hallway. That wasn't the public
Right.
hallway. What's
Right.
to deliberate about?
Right, and that plainly is the government's position. And again, it's not frivolous, just the opposite, right? This is one of those situations, Kim, where Rick is calling upon them to do two things. Remember the physicality of this. Remember the geography of this. Remember the doors, where those were. Remember the references to the stairs and how this happened. This was a defendant who was not walking in and out of the courtroom as you and I and others would do. Something atypical was happening here, and that's what he was identifying. And for your viewers, other people who look at that and say, that's all I need to know, that determination, that assessment, is not without merit either, right? Maybe that is all you need to know. The jury plainly is looking at that as well. It looks as if they're addressing other issues, but all of these things in a trial presented for a jury, and Rick was, as defense counsel tries to do as well, trying to make this simple, straightforward, invoking what we talked about a lot, which is common sense, your judgment based upon your own experiences in life. When someone goes through a door that is not the main public door, what does that tell you about what the defendant, the judge here, has accomplished? Defense obviously is saying it doesn't tell you much because of these other factors that we've identified. And that's, again, what the jury has to weigh here.
It is 8:25 p.m. It is exactly 6 hours since the jury first left the courtroom to begin its deliberations. I just we wonder what's going on in the courtroom right now. I know Ted has a question. Ted, I'll get to you in just a second, but we're watching Bill's notes, and there hasn't been much for a while. But at 8:10 p.m., he notes that Judge Edelman came out of his chambers without his robe and jokingly asked, are they still deliberating? Said he's now sitting on the other side of the bar at one of the chairs of the prosecution table, chatting with a court security officer, and then later sitting alone in the courtroom watching the goings-on. Finally, Bill Miston had occasion to ask Judge Edelman how his dinner was. He said it was okay. I asked what he had to eat, to which he said pizza. Edelman has now left the courtroom and went back to his chambers. I guess he didn't want any more probing questions from Bill Miston. Anyway, Ted Perry, you've got a question.
I know Bill was probably going to follow up and say, should pineapple be on pizza? And it was just too much for the judge to consider. Jim, I'm going to put something out here, and you say that means nothing. But I've gone back and I've read the criminal complaint, and this whole issue that came up tonight about did she know the exact name of the person on the warrant, right? And which has apparently been decided. But as I go back and read the criminal complaint, I see that the agents who were there did talk to the deputy and told them specifically who they were there for. And the deputy said, well, can you wait until after and go out in the public hallway? And then on the bench, Dugan found out that they were there. The bailiff, or the deputy here, it was testified, not by him, but by ICE agents, two of whom said, I didn't dime you out. I didn't tell on you guys. But yet he never took the stand. So is it possible that she did know that they were there for Eduardo Flores Ruiz? Because her deputy knew, even though there was testimony that he didn't dime them out. Thoughts on that? Or am I just looking for a conspiracy theory where one doesn't exist?
Right. And again, no conspiracy theories there. Again, we look to the four corners of the indictment. The criminal complaint obviously initially issued here based upon the affidavit that you're looking at and tells the story in much greater detail, even though this indictment was fairly specific. This goes again to the common sense that a juror would look to. All right, if your deputy, with whom you're having a lot of contact, right, The deputies are sitting right there. The deputy clerks, court reporters are there. There are a lot of people, a lot of staff there, not huge, but enough staff. And judges routinely are talking with them, right? And that's the point of the recitation of the narrative you just recited. Is it presumed that in that context, that the judge would have known that, yes, indeed, this is the defendant who is appearing in front of her, and he's also the focus of this administrative warrant? That's the kind of thing that the judge would also have instructed on, not specifically factually, but saying, okay, you can rely upon your own judgment. You can rely upon circumstantial evidence. You can rely on direct evidence. And it just in that context, there's nothing less compelling about circumstantial evidence, reasonable inferences from the relationships between the parties, reasonable conclusions based upon how they normally acted. All of that is contemplated by the jury, figuring out what happened. And to the extent, again, that there's this knowledge issue in the judge, what did she know about this particular proceeding? The word "of" becomes very important here. All of that can also be the subject of an awful lot of debate. It sounds as if it may well be. What did she know specifically about this proceeding? Could it be just generic, or did it have to be with respect to this particular defendant in front of her? Again, my guess is, based upon the two questions and back and forth that we've had, Ted, I think you probably identified what is perhaps some of the conversation going on right now in that deliberation room there on the third floor of the federal courthouse.
I am told by the voices in my ear we need to take another commercial break, so we're going to do that and continue with Jim Santel, with Ted Perry, with Kim Murphy, and myself, Brian Polson. Back with more after this. Something is happening in the courtroom we don't yet.
All right.
8:32 p.m. now. We are more than 6 hours into this thing. Mary Stoker Smith has just rejoined me again, and we just got word from Bill Miston that there was a knock from the jury door. The court security officer went inside. Now Judge Adelman is on the bench. Defense attorneys are entering court. Judge Dugan is back in court. And we don't know more than that just yet. Something is happening. We don't know if it is another jury question. We don't yet know if there is a verdict, but we are waiting to find out what this one is. And now we are hearing from Bill Miston. The verdict is in. We do have a verdict. It's going to be a little while because they've got to get all the parties assembled, but there is now a verdict in the trial of Hannah Dugan. We are waiting for the jury to be brought back into the courtroom. Bill Miston describes Nicole Maznica, one of the defense attorneys, rubbing Dugan's back as she stands at the defense table behind Judge Dugan. Stephen Biskupik has entered with the full defense team. The judge is there. I don't know yet about the government attorneys, but again, Bill Miston says we do have a verdict, and we are waiting now for the jury to come in. It has been 6 hours and 8 minutes since the jury first left the federal courtroom where this trial has taken place for the last 4 days to begin their deliberations. And here we are at about 8:33 p.m. on Thursday, December 18th, 8 months to the day after the events that took place at the county courthouse.
And we were wondering, Brian, were there multiple things that they were hung up on? Were they deliberating the jury for all this time since about 2:25 this afternoon, multiple items? Presumably it was this one issue that they were hung up on that they couldn't find clarity at. Perhaps there were more, but clearly this was a major hurdle that they have cleared with this jury. We just saw this motion coming in about 8:27, and now at 8:33, we do know that there is a verdict, and again, it will be a while before that's read, but Hannah Dugan back in that courtroom, as well as others involved in this case.
I can tell you, I've been on the air so long that I've got this is what we call an IFB. It's the thing where I can hear things. My battery's just run out, so I'm going to need another battery.
Yeah.
But,
well, while we do that, why don't we recap a little bit just while we're waiting here? And we're just looking at, I'll be watching for Bill's copious notes that he has been taking. So today this all wrapped up. As you know, this started a year ago to the date back on April 18th. And today we had day 4 of the Hannah Dugan trial here, with the jury deliberating now from 2:25 until 8:35 right now, where we know that there is a verdict. When closing arguments started today, the government went first, and they stated that Dugan used her judicial authority back on April 18th to replace the law with its own, quote, personal policy references. The defense stated that the jurors were, quote, given the ultimate check on government overreach and power, and the defense also argued that the case is really riddled with doubt. What does that mean? That this jury, these men and women, these 12 men and women, had the absolute job, if you will, they're paramount to all else stipulations for the day, where if you are going to convict or not convict, you have to have this without a reasonable doubt. And there are so many things that they are arguing that could have been given a reasonable doubt. The prosecution said, though, however, that Dugan acted corruptly and was doing her job as a judge, complying with the draft policy, and that they sent a man and his lawyers out of her courtroom. Again, that was the defense, but the prosecution was saying she was overreaching, and that obviously they should not bring their own personal opinions about immigration into this courtroom. There were several sticking points, and there was one in particular today that the jurors were kind of focusing in on. Jason Calvi was talking a little bit about that, but this has been...
Mary, I'll say, with regard to that sticking point, I think it not to predict what's going to happen, but we heard both Jonathan Lavoie and we heard Jim Santel tell us that the decision Judge Edelman made to say that definition, that jury instruction, only means that she needed to know of the government proceeding, but not whose proceeding it was, that was favorable to the government. If that was the lone sticking point, and now we have a verdict, it seems like that could have been favorable to the government's case. We'll find out shortly as the jury is on its way back into the courtroom.
All right. Yeah, they are. So we do have a verdict right now. We want to bring in, again, our legal expert right now. We're going to be joined by Jonathan Lavoie at our 9 o'clock hour. He's en route, but we are going to take a quick break here. We're going to get our notes together, regroup. But again, the jury is in. Keep it right here on Fox Local. We'll be back in just a moment to bring you the latest developments.
Ben Haleman from the Fox 6 studios. We got to interrupt your programming here to bring you breaking news. The verdict in Milwaukee County Judge Hannah Dugan's federal trial is in. The jury making their way to the courtroom as we speak.
We have a verdict now. Count 1 against Hannah Dugan, not guilty. Count 2, guilty. The first count, concealing from administrative arrest. Again, not guilty. We have a split verdict. Count 2, endeavoring to obstruct proceedings, guilty. So Judge Edelman telling the jury they are free to not answer or answer questions. It's up to them what to do after that. But that's what we have after more than 6 hours of deliberations, a split verdict.
And this came in fast. I thought that there might be a half hour for everyone to reset. We didn't know where Hannah Dugan was, if she was still in the federal courthouse or if she was waiting with her defense team, down the street. Apparently she was very close.
They were all in the courtroom.
And they're in the courtroom.
There was a knock on the door. They said the verdict's in. All the parties were there. I want to go straight out to Ted Perry, who's inside the courthouse. All right, Ted, here we go. This is a federal case, so that's why we don't have video, we don't have audio, but now there's been some movement, and here we go. Not guilty and guilty are the verdicts.
And we should point out that the not guilty is the misdemeanor and the guilty is the felony. So that is the more serious of the two. That is that she did corrupt to endeavor to influence, obstruct, and impede the due and proper administration of the law with a pending proceeding was being had before the department and an agency of the United States, namely in the arrest of EFR, which, as we know, stands for Eduardo Rios, for purposes of removal proceedings conducted by the Department of Homeland Security. So she did help him to evade arrest, and that is the more serious of the charges. We have a bank of cameras set up, hoping that we're going to get reaction from both sides here, but that is the story. I'm reading it just as you are, coming in from Bill Miston here as he is up in the courtroom. So I can't tell you the mood in the courtroom right now, but we are hoping to hear from Bill. Do we still have James Santel available to us?
That's a good question, because I think what's really interesting here is this is not the split verdict that was expected. And when we talked to attorneys throughout the week, both defense attorneys and prosecutors, they expected if there was going to be a split verdict, this was going to be the misdemeanor she would be convicted of and the felony she'd be acquitted of. It's the opposite. The felony is what she has been convicted of, according to what was relayed to us by Bill Miston in the courtroom. And if that is the case, my understanding is, from having talked to the experts throughout the week, that would be an automatic end to her career
Count
as a
one,
judge.
we find Hannah Dugan not guilty. Count 2, we the jury find Hannah Dugan guilty. That's the verdict that's coming down right now.
And I was wondering, with that count 1, concealing from the administrative arrest, was that the fact that Flores Ruiz was arrested? They weren't successful in concealing him, so
that's why it's always so interesting to get someone from the jury to open up and talk, to find out what was going on in that courtroom and why did you rule the way you did. I think we have a lot of questions about that right now.
And what is the impact going to be? What is the fallout going to be? There is jail time associated with the maximum penalties here, but federal prison time, with a conviction like this.
Potentially, though, probably not likely.
Probably
from
not
what
likely.
We've heard from experts.
All the
We've got
legal
someone
experts,
with no criminal background who's, in fact, in the opposite, obviously led a very productive professional life. It is not likely she would face anything near the maximum. Will she face any jail time? Of course, that remains to be seen, because there will have to be a separate sentencing phase where both sides will continue to make arguments.
And it's interesting. We have viewers. We were all afternoon on Fox Local. If you were watching us from the app or your smart TV, or maybe YouTube, and people on YouTube were commenting. And I agree with the assessment one person said, is that 95% who were on that YouTube chat at the time thought we would see 2 guilty verdicts.
Yeah.
So I'm curious how the public will react to the verdicts.
Ted, it was clear that this jury got caught up on something, because throughout the last few hours here, we have seen several questions asked from the jury to the people that were outside. So it was pretty clear that they had questions and they took their time with this.
And we're trying
Hi,
to
guys. I'm sorry. Was that for me?
Yes.
Guys, I'm so sorry. I was poking my head out the window to see if any kind of crowd had formed. I know we just got moments ago word that there was a verdict in, so I didn't know if there was any time for protesters or supporters or detractors to gather outside the federal courthouse. There does not appear to be just yet. But again, at 8:43, just getting news of this, you'll be curious to see what happens at 9 and 10 o'clock tonight as we go on air there. But I want to go back as we look at the closing arguments today and the government starting first, then the rebuttal from the defense, and then Frayling with the rebuttal to the closing arguments. And he really pounded home on this count 2, the second count, taking his time to go through everything in that case. From she told ICE to clear out the hallway. There was no draft policy in effect, so she can't claim that. She commandeered Judge Severa. She abandoned Severa in the hallway. She's directing things. That was her intent. She sighs when they learned that agents might be on other floors. Take the stairs. They pounded that home one more time. Take the stairs. It doesn't matter that they didn't take the stairs. It matters what her intent was, and I'll get the heat is what they closed on here. She knew what she was doing was wrong, according to prosecutors.
You know, the hang-up that they talked about having was a question of did they need to know in that second count who the individual was. In count 1, the jury instructions are clear that the 4 elements they had to prove were that there was a federal warrant arrested for an individual, that the defendant knew of that warrant, that the defendant harbored or concealed the individual, and here's the last one, the defendant intended to prevent the individual's discovery or arrest. That's the one she's acquitted on. The one she's convicted of, the elements are that there was a proceeding being conducted by an agency of the United States, that the defendant knew of that pending proceeding, that the defendant endeavored to influence, obstruct, or impede the proceeding, and the defendant did so corruptly with the purpose of wrongfully influencing the activities of a federal department or agency. The second count, even though it's more serious, doesn't say anything about an individual.
Yeah.
So she knew there was some warrant for someone, and she did something to obstruct, and the jury determined that was enough on count 2. But count 1 was so specific to Eduardo Flores Ruiz, they found they didn't have it.
Let's bring in James Santel, former U.S. federal prosecutor. What do you make of this split decision from the jury?
It is, once again, as we were saying earlier, it's an affirmation of the jury process, right? You've got a jury here that spent a good deal of time, as you're indicating, much more than 6 hours here, and they did their job. That's not to say that we're embracing or not embracing the result, but the fact that you've got a jury that looked at the language, plainly looked at the kinds of things, Brian, that you just identified, what are the elements of proof, and said that as to this count, the government has not met its burden beyond a reasonable doubt. Here on the other count, the language, the elements of the offense, here we can make a distinction and find that indeed there was sufficient evidence beyond a reasonable doubt. That, to my mind, speaks volume about this jury and the very particular job that they undertook. The questions that they asked also reaffirmed that. As you were just indicating, if the judge does give the attorneys permission, with the consent, again, of any particular jurors, there could be some consultation with them. That will plainly not happen tonight. But you could do a little bit more inquiry if any jurors want to speak, and there is an interest in doing that. The other thing that we should think about right now is what's going on right now, which is what happens next in all of this. Plainly, there is an issue about the status of this defendant. She is not a risk of flight. She's not a danger to the community. We don't know that yet from the reporting, but I anticipate fully that Judge Edelman will release her tonight on her own recognizance, probably schedule either tonight or very soon a sentencing hearing down the road. That will be weeks, could arguably be even longer than that. This is all going to be under the sentencing guidelines, and that's the reason why we're talking about the likelihood or lack of likelihood of her suffering any jail time. She is almost certainly at the lowest categories when it comes to those sentencing guidelines, giving the judge some prerogative, some discretion, but unlikely that she is going to be sentenced by this judge to any serious or any time in prison. Note as well that even these things related to the answers to the jury questions, what can those be? Those can be a part of the appeal, right? Because presumably the defense was not successful in arguing about this definitional issue. That assumes that it's about the second count here. And that, again, with many other things, can be the focus of an appeal. Hannah Dugan, under the system, has an absolute right to appeal this conviction to the Seventh Circuit Court of Appeals. That is traditionally done after the sentence is imposed. Likely that Judge Edelman might even stay that sentence until such time as the Court of Appeals reviews all of this, including any objections, including any opposition to what happened in the courtroom for the past 4 days that are presented to the appeals court in its review of this overall case. So a lot of procedure, a lot of process here, and this will be in the news and plainly on your dockets as well, the dockets of all Americans, certainly those of us in Wisconsin here and beyond, for a number of months, could arguably be well into 2026 before presuming an appeal, before the Court of Appeals resolves that. There are oral arguments in front of the Court of Appeals about all this. And so the process continues. This is undeniably a very big event, and it is certainly a watershed event, but it does not conclude everything that will be happening in the near future.
Hannah Dugan, guilty of felony obstruction. Jonathan Lavoie is here on the set. What's your takeaway just instantly after this verdict comes down?
Well, we talked a lot about today. The jury was having trouble, and they were arguing the case and talking about the case. A split verdict makes some sense. It probably was a compromise where they talked it through, and it came down to that element that we talked about a lot today. I think they were concerned about one of the jury instructions, and I believe they felt the state just didn't prove their case on the obstruction.
Was it a surprise, though, that if it was going to be a split verdict, that it's the felony they find her guilty of and the misdemeanor they acquit her of?
Juries are a mystery. So I'm not sure the jury knew the severity of each of the charges. They're just provided each of the charges, and they have to make the decision based on the elements. So I think the jury carefully analyzed the elements of each of the offenses, and they rendered their verdict based on what they thought the evidence was.
Do you think at any point Hannah Dugan considered testifying in her own defense?
I think they absolutely considered it. I bet you it was a game time decision where she likely decided not to. Of course, now it's armchair quarterback time.
Right.
Would having her testify made a difference in the outcome of her case? I don't know. But I thought it was important for the jury to hear her side of the story. Their defense strategy was to focus on reasonable doubt and focus on hoping the jury saw it their way. And it was a split verdict, so I guess it's good that she didn't get convicted from her perspective of the misdemeanor, but she went down on the obstruction.
This seemed to come down to a discussion over these very specific elements, and the judge had to make a pretty controversial determination over one. Does that sort of maybe at least offer some comfort that this wasn't just a jury that went in and debated politics, that they really looked at the law and said, what do we have to find here to find a guilty verdict?
There's no doubt this jury knew this was important. This has national implications. This is a big trial that impacts a lot of people. I'm convinced the jury spent a lot of time and effort carefully reviewing the jury instructions, listening to what the judge told them. And I feel like, we should be happy that a jury spent that kind of time and effort to get it right, to do the best they can. I mean, we're asking citizens to come in off the street and to hear some of the most important affairs that we have in our court systems.
What is the implications here, especially nationally? I think we've got someone coming up to
Brad
the podium.
Schimmel.
Let's take that podium shot, and let's hear from the acting U.S. Attorney, Brad Schimmel. Again, he's got 120 days on this job. He kind of came in the middle of this.
And we were wondering if there was possibly a deal tendered. We don't know that, but let's listen to his reaction to the split verdict in the Hannah Dugan trial.
Well, good evening. It's been a long day. I don't plan to have a lengthy discussion here, but there are some important messages that I would have said no matter what the verdict was tonight. First, we all owe a debt of gratitude to the jurors for their service and dedication. They worked hard. Our justice system is not always perfect, but it's the best the world has to offer. And much of the credit for that belongs to citizens who sacrificed to serve as jurors. And our justice system would not work without their service. Second, we all need to keep this case in proper perspective, and I hope that all viewers, readers, listeners will pay attention to this. Some have sought to make this about a larger political battle. While this case is serious for all involved, it is ultimately about a single day, a single bad day in a public courthouse. The defendant is certainly not evil, nor is she a martyr for some greater cause. It was a criminal case like many that make their way through this courthouse every day, and we all must accept the verdict peacefully. The third thing that I would have said either way, although the majority of the work on this case took place prior to my appointment, I have witnessed the incredible hard work and extraordinary talent of the team here that put the final pieces of this case together over the last month. I'm immensely proud to be part of that team. The team was led by First Assistant U.S. Attorney Richard Froling, Criminal Division Chief Keith Alexander, and Deputy Criminal Division Chief Kelly Watzka. Those three worked tirelessly 7 days a week for several weeks now to prepare the presentation of this case, and based on my years of experience, it was tried masterfully. Of course, the team was larger than those three assistant U.S. attorneys who appeared in court. Many other attorneys, law enforcement investigators, and litigation support staff also worked long hours to put this together. On behalf of the people of the United States that we serve, I thank all of them for their diligent efforts. I reiterate that all of us need to keep this case in proper perspective and peacefully accept the verdict. This is a serious matter for which the United States government found it necessary to seek to hold the defendant accountable. Experience and common sense, as well as the evidence presented in this case, demonstrate that the safest place to execute an arrest warrant is within a public area of a courthouse, such as the Milwaukee County Courthouse, that is security screening to ensure that none who enter, except law enforcement, are armed. That's why the federal agents sought, as law enforcement does every day, to utilize that safer environment to accomplish this arrest. But the defendant's actions provided an opportunity for a wanted subject to flee outside that safe courthouse environment, which led to a dangerous foot chase through automobile traffic and eventually to an agent taking the subject to the ground, which is always hazardous for both the officer and the suspect. There was certainly potential for many other dangers as well. Thankfully, no one was injured in that apprehension. Law enforcement work is fraught with dangers, and our law enforcement officers put their lives on the line every day. Here, they were carrying out their sworn responsibility to execute an arrest warrant. When they perform their duties, they should reasonably be entitled to do so in the safest possible conditions. When someone, especially a sworn public official, puts them in unnecessary danger by obstructing those efforts to make an arrest as safely as possible, they must be held accountable. The defendant exercised her constitutional right to put the government to its proof. We met that burden, and the jury has found the defendant guilty. It will now be up to the judge to determine what are the appropriate consequences. We'll have more to say about the circumstances relating to the case at the sentencing hearing. I can take a few questions tonight.
What do you think this split verdict says to the community?
Well, it was two different charges. The jury had to consider two different sets of elements. They worked hard. They concluded as to one, the defendant was not guilty, that we didn't meet our burden of proof. As to the other, we did. That it happens with some regularity in the court system.
Hey, Brad, did anyone get offers of immunity in this case, any of the witnesses?
Not that I'm aware of.
What will the government be asking for when it comes to sentencing?
Those were a little far off from those determinations. You may have heard the judge set a briefing schedule relating to judgments on the verdicts, and once that's through, there will be a pre-sentence investigation report that's filed. We'll make all those determinations once we have all of the information we should have before that.
Could you just repeat what the jury ruled on which count and what the exposure is for Judge Dugan on maximum penalties?
I don't have that in front of me. The jury acquitted Judge Dugan on the misdemeanor count. They found her guilty on the felony count. I don't remember what the exposure is.
Brad,
You have a lot of experience working in state courts as a former prosecutor and district attorney. What do you think this verdict will do? What message does it send to other county courthouses about what potentially will happen in the future?
You know, I'd like to think that although until trial the defendant had maintained her innocence, I'd like to think that she looked back on this from the get-go with some regrets about what she did that day. She certainly did seem to, in those communications in the days following, where she had conceded that she was in the doghouse with the chief judge, I think she recognized this wasn't the right way to do things. I understand the concerns that Chief Judge Ashley expressed in that press release that became part of the evidence here. However, law enforcement is going to execute arrest warrants. And frankly, in most cases, the arrest warrants are issued by a judge. Law enforcement should be entitled to identify the safest place to do that. And a circuit court building that has a metal detector and security check-in at the front door is among the safest place to do that. And a circuit court building that has a metal detector and security check-in at the front door is among the safest places we can find. I heard suggestions during the trial, well, why didn't they do a traffic stop? Traffic stops are inherently dangerous. You've all reported on the news of traffic stops that turn into dangerous chases where citizens and police officers sometimes get killed or hurt. That's not a safer way to do it. This was the safest way to do it. Like I said, I understand the concerns that Chief Judge Ashley expressed, but in the end, this is a way to do it that is safer for everyone.
There's been discussions recently about this case, the outcome having impacts on judges across the country, what they are or not able to do in their own courtrooms. What are your comments on people who may be concerned coast to coast?
Well, there was an important distinction made in the draft policy from Chief Judge Ashley and in the evidence in this case. This wasn't something that happened within the judge's courtroom. It was in the public hallways. Frankly, in my time as a judge in Waukesha County, we had a similar request of law enforcement that if you were there to execute an arrest warrant, that you let us call the case first. Let's get through this so that we know what's going to happen next. We don't unnecessarily, as the sergeant from the Sheriff's Department testified, you don't unnecessarily issue an arrest warrant for someone who didn't show up because law enforcement stopped them before they got in. That all makes perfect sense. Do it in the hallway. That is an important distinction here. Yeah, Mr. Biskupic.
I'm only going to stay a little bit, and then Mr. Schimmel can have the podium back. Just the defense comment is obviously disappointed. The mixed verdict is the big thing from the defense perspective. You know, the same elements of count one are in count two. In count two, how can you find guilty there and not guilty on the first? But that's why we asked for the post-trial briefing. Judge hasn't set a sentencing date, so obviously he's going to take this seriously as well. And I would just say the case is a long way from over. Thank you.
Steve, any reaction from Hannah on that verdict?
Same comments.
Yeah.
Brad, what about the idea that immigration enforcement chills access to the justice system in Wisconsin, Milwaukee? Now, that was a theme in this.
There are immigrants who come to court as victims as often as there are immigrants who come to court as defendants. If you have a warrant for your arrest, you should be expecting that somewhere, sometime, law enforcement's going to catch up with you and execute that warrant for arrest. It isn't unfair that law enforcement chooses that place, a public hallway at a courthouse, to do this.
Do you have a response to the defense saying that the Trump administration was trying to make an example out of Judge Dugan?
This office is a professional law enforcement agency. We weren't trying to make an example out of anyone. This was necessary to hold Judge Dugan accountable in our assessment because of the action she took. That's what we did. There isn't from our perspective in this office, there's not a political aspect to it.
Were there any conversations coming out of the U.S. Attorney's Office about this specific case and what was happening this week?
You mean the Attorney General's office?
I'm sorry.
Yeah.
The U.S. Attorney General. Were there any comments from the AG, Pam Bondi?
We have, not directly from the Attorney General. There is a member of the Executive Office of the United States Attorney that manage the U.S. Attorney's offices nationwide that has requested that we keep them advised of the proceedings. That's been the extent of it.
Do you see Dugan as a victim in this at all, just by the fact that the Milwaukee County Courthouse did not have a clear policy on immigration arrests inside that building?
Well, this case was well underway before I was appointed as United States Attorney here. So I had to get up to speed with what others had been working on. I don't see her as a victim. She made choices. She knew what the policy was and the policy was not. It was clear in the evidence that the policy, and Chief Judge Ashley testified this as well, the policy that they were looking at implementing dealt with what happened in the judge's courtroom. He acknowledged there is no basis upon which they can preclude law enforcement of any kind from making arrests in a public area of the courthouse. She knew that. All right, thank you. It's been a long day. It's been a long week for all of you too. Good night and Merry Christmas. Happy holidays.
All right, we just heard from Brad Schimmel wrapping up, U.S. Eastern District Attorney on this, thanking first of all the jurors for their service and acknowledging that they really put in the work to carefully come to the split decision.
Pretty extraordinary moment, though, right?
I thought this was I've never seen this before, where the prosecutors are giving their post-press conference and the defense kind of says, get out of the way, I've got to say something, I want to get out of here. And then, Jonathan, we got to bring you in here because this was really fascinating. What the defense just said, saying this is far from over, and making some points that we're going to be talking about in the days to come here.
Right, so Steve Biskubik indicated right now that this is an inconsistent jury verdict, that it doesn't make sense for a jury to convict on one count and not the other. So he's indicating that they're going to file a motion to dismiss, asking the judge to essentially overrule the jury's verdict and issue a final decision of not guilty on the obstruction charge based on the fact that no reasonable jury could come up with a mixed verdict like they did. That's what he's saying.
And I think that's one thing that people don't always necessarily understand is when the jury renders its verdict, it's not a judgment until the judge enters that judgment. And this is in between that phase where they're asking for that. Is that right?
That's correct. It's an extreme measure for a judge to overrule the finding of a jury. It's not typically done, but the judge ultimately has the power to put the judgment of conviction on the record, and the judge makes the final call.
I want to bring Jim Santel in here. Jim, you used to be in Brad Schimmel's shoes up at the microphone. I don't ever remember somebody booting you, asking you to move out of the way to make a comment before, but what is your reaction to what the defense is saying here about, hey, how could you find her guilty, not guilty on one, but guilty on the other?
That issue, which Steve has articulated tonight from that podium, is something, again, that he will raise and is going to raise before Judge Edelman and say that basically the verdict of this jury is not reconcilable between the two counts, and therefore, Judge, throw out this verdict and let's start over. That will be, again, a motion that he will file fairly soon, presumably. The judge has set up that briefing schedule. And then when the judge has resolved that and presumably is not going to interrupt and not going to upset the decision of this jury, then he will also sentence Judge Dugan under the particular statute, but also the sentencing guidelines that apply to this particular offense conduct. We've got weeks and months down the road, as I said earlier, and there's a lot of proceedings here yet to undertake. not the least of which is after all of this is done, there is almost certainly going to be an appeal to the Seventh Circuit Court of Appeals. And in that setting, depending upon how the judge resolves even this post-trial motion, anything else that came up during the course of pretrial proceedings, going back as far as the judge's decision not to dismiss this case upon 10th Amendment positions and arguments, all of those things, including evidentiary rulings during the course of the trial, including jury instructions, which we saw just this evening, all of those things can be identified by the defense as reasons to appeal, not only to appeal to the Seventh Circuit, but also to seek the Seventh Circuit's decision that because the lower court acted improperly, did not resolve those issues correctly, the case should be returned for a new trial or the judgment should be simply dismissed. There is a lot yet to happen here. I agree with Steve entirely. But the verdict still is the significant event in this matter, certainly tonight and going forward. It animates everything that happens after this. Had there been a not guilty verdict on both counts, we would then have seen the discharge of the defendant, and we would not have anything further to talk about in terms of proceedings here. We've got a lot more to talk about now, including these motions, and including sentencing memorandums, sentencing dispositions, and post-sentencing appeals, almost certainly to the Seventh Circuit Court of Appeals.
Because I'm looking at the notes here.
Can I just interrupt you?
Yeah,
if you could hang with us just for a couple of minutes. Our Jason Calvi has been staked outside of the federal building, and he actually got a word with one of the prosecutors. If we have that sound, can we toss to that? Our producer, Michael?
You got to turn it on. Hi there, can we get your thoughts on the trial? Hi there, what are your reaction to the guilty, not guilty?
All right, so we did hear from their boss, Brad Schimmel, obviously the acting U.S. attorney, but he's not part of that prosecution team. No word
and did not
for Jason.
prosecute.
Well, it's good we got lawyers here. There's reasons they don't want to talk. We're talking about all these issues that are not yet concluded, so that maybe you don't want to make a statement outside of what's happening in court, because this fight, Jonathan, is not over according to the lawyers.
That's correct. I think it's very common for the government not to give a big statement about certainly the facts of the case, because you're right, it's not over. There's going to be more litigation, and they don't want something they say to the media tonight to be used against them later in court.
Speaking of the things that are still to come, the defense asked for this briefing over their request for the judge not to accept this jury verdict, to dismiss it. We have a schedule that's been laid out according to the notes from Bill Miston. January 30th of 2026 is the deadline for the initial motion from the defense, and then the government asked for 3 weeks for a response. They set that for February 20th of 2026. Another 2 weeks after that for a response from the defense, which would be March 6th. So just this briefing alone takes us out into March of 2026, and that means there won't be a judgment of conviction entered at least until the second quarter of 2026. So even though the jury found her guilty, am I right here in saying that technically she has not been convicted and won't be until the judge enters that judgment of conviction?
Correct. There's been a guilty verdict rendered. It hasn't yet been received by the court, so we're in sort of a limbo status right now.
That is an unusually long limbo period for something like this, is it not?
Not necessarily. In cases where the defense is challenging the verdict, it's common for there to be briefing and argument before the court. Sometimes the court will accept the judgment and then brief, but in federal court here, this judge wants the briefs to take place before he makes that final decision.
Maybe I'm curious, how often or how common is it then, and this is a question for either of you gentlemen, how common is it for a verdict to be challenged in this fashion?
Mr. Santelli might be in the best position to answer that.
Sure. This is not atypical, especially in a situation like this. I've seen it repeatedly in the many years that I was a prosecutor. And again, it's a part of a system. We embrace that. And so what will happen here is the briefing will be done in March. We've got to afford the judge some time to review all of that. He may issue his decision April, May, that sort of time period. And then we'll again go ahead and schedule a sentencing hearing. There has to be a pre-sentence report prepared. All of that brings us probably well into the summer of next year. And just in terms of the language, the judge tonight is convicted. She has been convicted by a jury of this second count. You're absolutely right, Brian. What hasn't happened yet is the judgment has not been entered. That sounds like a lawyer talking, and it is, but those distinctions are important in terms of what happens. You only appeal from a judgment entered by the judge because the Court of Appeals wants to look at everything that happens. So there's a conviction tonight. She has been found guilty of that second count. The judgment will be withheld until all these post-trial motions are disposed of, and anything related to sentencing is also addressed by the judge.
I'm putting
James,
a bookmark at
I
9:14. I just want to remember that because for story scripts, we need to know everything you just said. That's good to know.
What effect does tonight's verdicts will it have on other courts tomorrow?
The answer is, as the U.S. Attorney Brad Schimmel just said tonight, as a purely legal and factual matter, the answer is none, right? The jury found tonight that this particular defendant is in fact guilty of this offense conduct. The actual event here tonight shouldn't have an effect upon other court cases. There is none out there pending. It may be that your question is focused upon what kinds of things, for example, will Judge Ashley be doing with respect to his policy. That's a different issue. But the issue about what happens here in this case, again, it proceeds in front of Judge Edelman, ultimately the Seventh Circuit. It is a discrete package inside that process.
I think protesters who've been outside the courthouse all week have tried to make the argument this was an overzealous prosecution and that these charges should have never come. I thought it was really interesting when we heard from Brad Schimmel. Did you notice the tone? He said she is not a bad, I don't want to be misquoted here, not a bad person. She's not a martyr for some sort of civil cause. This was a bad day and she made basically the wrong choices. He was trying to tone down the bigger argument that a lot of people have been making and why this case has gotten a lot of national attention.
But you remember when this first came out, this did go into the Attorney General was talking about it and other individuals in the
FBI director
administration,
released the picture of the arrest.
So it was at first sort of a big deal, and the government was trying to make a big deal out of it. And I think that's why the community was upset, that they thought maybe this was being pushed upon Milwaukee by Washington, and that this really didn't need to happen.
The tone changed, didn't it? I mean, by
Mr. Schimmel, Attorney Schimmel is trying to tone that down now and say, look, this is just another case. But I'm not sure I'm buying that. I think this isn't just another case.
But we remind people also that this jury is not exclusively from Milwaukee County.
That's right.
And
That's correct.
District of Wisconsin,
yes.
yeah.
So
I think really it is an interesting contrast that she was in handcuffs at the beginning of the case. She leaves the courthouse tonight convicted, but without any handcuffs and goes home. That's a really interesting contrast. Yeah, Jim?
And it goes to this issue, which is detention, which is apart from the underlying charges and the conviction. The question always is this particular defendant, whoever you are you a risk of flight? Are you a danger to the community? Effectively, what Judge Edelman has said tonight by releasing her is you are neither one of those. And frankly, I would offer, as a former prosecutor, former U.S. attorney, I do not believe that Hannah Dugan ever was a risk of flight. And the danger of the community is not categorized with this kind of offense conduct. I would also say to your previous comments just about what Brad Schimmel has said, let's do some important civics tonight. Understand that language is important. We do not prosecute people in this country because they're bad people, because we don't like them. That's not the standard. We prosecute people because they've done things. We prosecute for them for their conduct, not who they are. And that's the comment that Brad Schimmel, again, I believe, was trying to convey. An important lesson also to take out of this prosecution. And the reasons for doing prosecution, absolutely necessary to ensure our safety, our security, upholding the rule of law. all of that depended upon abiding by those fundamental notions about why we do prosecution, why it is that sometimes people are in fact sentenced to prison, deterrence, both specific and general deterrence. All kinds of principles are going to be coming into play here. But it's important to distinguish, again, this notion that somehow there are bad people out there, and for that reason we've got to put them in jail. We put people in jail, we sentence them based upon conduct, not their own value as a human being. That's been our tradition, again, for 250 years.
Is it fair to say Judge Hannah Dugan will no longer be a judge? Her career has ended with this felony conviction.
I believe that with a felony conviction, if that stands up with Judge Edelman's final ruling, that she will absolutely no longer be a judge, and she'll likely suffer some other potential bar issues.
Could she even be a lawyer?
That's up to the state bar and ultimately up to the state Supreme Court. She's essentially at retirement age. I'm not sure whether she's going to want to come back to being a lawyer at this point based on everything that she went through, but I think her judgeship is over.
I know we've got crews all over the federal courthouse area right now, and I don't know who's got what or who we're ready to go, but is there anyone we can go out to there to get a vibe of what's happening down at the federal courthouse right now? Because I think we have crews crawling all over the outside
Christina
of that
Van
building.
Zelst and Jason is down there. They're both trying to, because we haven't seen Judge Dugan leave. We don't know if she's left through a different exit, so we are trying to cover
I think
that
we've
huge,
got Ted Perry in a minute here. I think he's putting his
courthouse.
mic back on. He's still in the spot.
Jonathan, you get your clients right out of the courthouse? I mean, you're a defense attorney. Is there an exit strategy? I mean, is this all planned out?
In a situation like this, I would definitely want my client out the back door. So, if she would have, been acquitted of all charges, obviously she'd be coming out the front door. But I'm certain that they had some type of exit plan, or maybe she's waiting for the press to leave a little bit, and then she'll sneak out later. I'm not.
There's been a couple times this week where she's come early, like before any of the press.
Right.
She was already in the building as she knew that people were going to be out there to see her come in the building every day.
Not to be flippant, but for all the years that I've covered court cases, that's where we always wonder where are the secret hallways. And this was a case that was all about a non-public hallway. I'm not being funny. It's something we've always. Anyways, let's go to Ted Perry, who's back out at the federal courthouse.
Guys, what can I tell you? It's been a remarkable last 30 minutes here, and we are in this workroom where we've been all week, and crews are starting to pack up and leave because they've been very gracious to let us broadcast from here. It's very unusual to be able to broadcast from the federal courthouse, from inside the federal courthouse, but we were told at 9:40 lights are out and we're going to have to get out of here. So Christina and Bill Miston are already setting up outside to bring you reports later as they try to get, Judge Dugan, who is able to speak, any of her attorneys. We did hear from Stephen Biskupik as Brad Schimmel, the acting U.S. attorney, was talking and going over the case, which you guys have summarized his comments very well. It was very odd to see Stephen Biskupik walk in, kind of take over the podium for a few seconds, make his statement about how they're disappointed and a little confused about having the same elements in both charges, and you could be not guilty on one and guilty on the other, and then left. And someone said, do you have a statement for Hannah Dugan? And he said, it's what I said goes for her as well. I don't know if you've read the statement from her team.
I got from that, the fight is not over. And I want to caution on that statement that we have. It's not from her defense lawyers. There is a Hannah Dugan Defense Fund, and the statement was released from those who are associated with that fund. I'm not really sure if Hannah Dugan is associated with that fund, but there is some reaction from those who supported her that they are disappointed with the split verdict.
I know we have that moment on tape, the moment you just talked about, Ted, the one where the former U.S. attorney interrupts the current U.S. attorney as they're giving their statements. Is that some? Oh, first of all, this is that statement from the legal defense team that you were talking about, Kim?
Right. So this is not this. We don't think is related to the attorneys or defense attorneys who tried this case, who represented her in court. But there is a Hannah Dugan Legal Defense Fund that is raising money.
Kim,
yes.
I think you're right, Kim, because, it does say the Hannah Dugan Legal Defense Team. It was Biskupik who spoke, and he didn't say we put out a statement already.
Yeah.
He came in, said what he had to say, and then left. So it might be misleading that this the statement that we have says the Hannah Dugan legal defense team, but it comes from paththovictory.com.
Do we have, guys, do we have that moment where we
do.
actually hear the defense? Can we play that right now?
Yeah.
Because I also thought that was a really, I've been doing this a while. I haven't seen a lot of moments like this, so let's watch it.
Just the defense comment is obviously disappointed. The mixed verdict is the big thing from the defense perspective. You know, the same elements of count one are in count two. In count two, how can you find guilty there and not guilty on the first? But that's why we asked for the post-trial briefing. Judge hasn't set a sentencing date, so obviously he's going to take this seriously as well. And I would just say the case is a long way from over. Thank you.
I think we needed to go back almost like 10 seconds earlier to see the best part when he steps in and says, "Let me go," while you're
and
still
then Brad
talking.
Schimmel, when he's like, "Okay, I'll jump back
here.
in."
We've tried to say that this is not a political case, but Tom Tiffany, representative, just posted on X, guilty, now lock her up. Hannah Dugan obstructed federal agents attempting to arrest an illegal alien with a violent criminal history, including strangulation, suffocation, battery, and domestic abuse. But that is not, we want to clarify, that was not in the warrant. The suffocation and those allegations were not the reason why he was being sought by ICE. But again, we see that politicians are now starting to wade into this and react to the split verdict.
And it won't be the last political statement we're going to get about this. I mean, this is just because where we started. I know what Brad Schimmel was trying to say from the courtroom, but we have to remember what environment that this case is being tried in and where the country is, and some of the players in Washington who talked about this case and put a giant spotlight on this.
I kind of almost wonder if all the press releases were ready to go out, whether there was a guilty verdict or a not guilty verdict. Maybe they weren't ready for a split one.
Yeah.
And now they've got to reconfigure these things. I know we've got Jason Calvi, who's out at the federal courthouse. I think he's outside the courthouse now. He's been in the Milwaukee County courthouse all week. But Jason, what is the scene out there? What are you seeing? We know you tried to talk to the prosecution team on their way out. They didn't say much. What else is going on out there?
Yeah, they didn't say much at all, and we did see at least one juror walk out, also didn't want to talk, and we have to respect that. We can ask once, and then that's the end of the conversation with those jurors, so they have the right to not have to talk if they don't want to, and then we respect that. So that's what we've been seeing here. I also saw the interim, his official title is interim U.S. Attorney for the Eastern District of Wisconsin, and I saw him leaving through, it looks like a garage area, through the middle of this area where we're standing in front of here. I believe this is Jefferson in Milwaukee. But I had a question for the legal experts. It was interesting because the jury on the two issues, the jury had two questions, one question on each of those particular charges, and on the first question it was whether or not Judge Dugan needed to know the identity of the person that they were there, that the ICE agents were there to arrest, Eduardo Flores Ruiz. Did she need to know the identity? And the answer simply from Judge Edelman was yes. That was what that's what the defense wanted, and that's what they got. And that charge of shielding him from arrest was the one where she was not guilty. On the second question they went to the judge, the jurors went to the judge asking about, was whether or not same sort of issue there. And in that instance, he sided with the government in answering that question. So I want to ask our legal experts who are listening, is that part of, what do you make of the fact that that the judge sided with both parties on the two different questions, and that's where the jury split their vote tonight?
Jonathan, should we start with you? Your take on them. Those questions I thought was interesting because, as Jason just pointed out, on one, and here we were talking about the judge really didn't make he was a side character for a lot of the trial, and then here, when the jury asks these critical questions, he makes decisions about how they are going to be answered. And as Jason points out, the way that they went back to the jury, it seems that that's the way the jury went.
We talked about that earlier today, that we knew when that jury was instructed the way it was by Judge Edelman, that was a tremendous advantage for the state, and that's how it ended up.
With the guilty verdict.
I think it's interesting because when you're asking these really fine questions about a jury instruction and both sides disagree and ultimately the judge has to make a call. We've done a lot of sports analogies this week, but this is kind of like the referee on the field having to make the decision that decides the Super Bowl. and they do, and it goes a certain way, and now you've got Steve Biskupik saying, I'm throwing the challenge flag. We don't agree with that, and we're going to challenge it.
That's exactly right. And what a judge says to a jury is very powerful and can put the foot on the gas on one side or a brake on the other. And clearly that was a very important part of this case, and I will expect will be part of the post-conviction motions and appeals in this case.
So what does March look like? Because we're not going to, that's the next step in this case.
Right, so the judge will make a final determination as to whether to enter the judgment on the verdict. Assuming that he does that, then we then proceed to sentencing, where her punishment is determined, and then we probably will go on for years of appeals.
Jason, you're still out there. Is anybody milling about? Are there any demonstrators? Is it all quiet? What are you seeing out there?
The only people I see are very, very cold media that are standing out here waiting for potentially. I've been asking my colleagues that are on various parts of this building, have you seen Judge Dugan? And nobody has seemed to have seen Judge Dugan leave the building. So maybe the experts that are on can tell us, where that secret exit is. But yeah, it's pretty much just the media. It's very, very cold. It's gotten cold. The wind is now coming in. We'll get an update on the weather in a little bit here from Tom, but it is very cold. And really right now, it's just the media out here.
And the federal courthouse is shutting down. Ted said that he has to be out of his room by 9:40.
Yeah.
So let's do one more really quick check-in with Ted before you have to pack up and get out of there, Ted. Your closing thoughts on how this all went down and the questions that the jury asked and just this whole result.
I'm not going to be able to add anything that you guys haven't done masterfully. I mean, it's the same questions that I'm asking about the split decision here. You made the sports analogy, Brian, a few moments ago. It's sort of like when that first not guilty, it's sort of like winning the NFC Championship and then losing the Super Bowl, the one that really matters. Well, the one that really matters, the one that gives her a felony conviction, is that count two. And again, I just want to emphasize, in closing arguments today, Frayling, the prosecutor, pounded home a list of topics that he wanted jurors to remember. That was the last ringing of the bell that they heard, and that clearly stuck in their minds because they came back on the conviction on the felony, which carries 5 years in prison and a $250,000 fine, although sentencing, as we've talked about, is many, many, many weeks down the road.
Ted, I know that you are going to have to abandon that desk you've had all week long there at the federal courthouse, come back to your desk here at Fox 6. I'm sorry to say you don't have a heater that can cook your food anymore. Throughout the week, we've seen Ted, cooking the sandwiches on the heater.
It was fun while it lasted. Yeah.
We just want to quickly play here. This is Brad Schimmel talking about the split verdict here, the guilty verdict and not guilty verdict. Let's listen.
Some have sought to make this about a larger political battle. While this case is serious for all involved, it is ultimately about a single day, a single bad day in a public courthouse. The defendant is certainly not evil, nor is she a martyr for some greater cause. It was a criminal case like many that make their way through this courthouse every day, and we all must accept the verdict peacefully.
All right, there is much more of our coverage of the Hannah Dugan trial. It is over after hours of deliberation today.
Yeah, and here again, it's a federal obstruction charge. Jonathan Lavoie is here from Kim Lavoie, and it's just, we haven't had a case like this, maybe ever, in Milwaukee County. What kind of ramifications now does this have?
So who would have thought that a sitting circuit court judge would be convicted in federal court of a felony? It's a big case. It's really unprecedented. We haven't seen anything like this before. It's a difficult case because in our community we have people on both sides of the coin with very strong opinions. But at the end of the day, the jury spoke, and the case probably isn't over yet. But at least for today, we have a guilty verdict on the felony.
I don't know if we still have Jim around, but I'll ask you this. I could ask you both this. I just wonder, in your careers, have you ever even had the occasion to do direct questioning or cross-examination of a sitting judge, much less 4 in one case?
Never. That's very, very unique that a judge would be in this situation, let alone one judge plus 3 other judges. Such a unique situation. Very difficult for the lawyers to have to manage cross-examining judges that they appear in front of, and you could tell how nervous people were and how scared people were over this whole situation. It was a difficult trial for a lot of people, and I think everyone's glad it's over.
Jim, how about you? Have you ever had to cross-examine or do direct examination of a sitting judge?
Not to my recollection, and again, that's based upon about 30 years of prosecution. I will tell you that when I was in Iraq, we had a lot of interaction with the judges there. A very different system, a very different approach, and in that setting, because of the unique situation, yes, we did have engagements with judges in this kind of a forum, but I'd offer once again that what you're observing is something that your viewers should take away. The extraordinary nature of this. We have a federal judge who's presiding over a trial of a circuit court judge who is in his courtroom. And during the course of that proceeding, there is testimony from the chief judge of the circuit court from which the defendant comes. And then there is testimony from 3 other circuit court judges also appearing there, all of them also sitting judges, none of them in an expert position, that is retired judges who are offering some perspective based upon years and years. They're talking about things that have happened recently, their exchange of emails about the protocols there. This is an extraordinary proceeding, and putting aside, although it's difficult to do that, the significance of this verdict, the process itself is one that I dare say that we're not going to see again, if ever, in this kind of a setting.
All right, we got to get out to Bill Miston. He was actually in the courtroom, and all of us we have a picture, a drawing of the reaction of Judge Hannah Dugan. Bill Miston, appreciate you being with us now. So bring us into the courtroom the moment that this verdict came down.
Well, leading up to it, once we saw that the court security officer had come out of the jury room without a slip of paper, we knew that they were close considering the types of questions that they were asking and what questions were being asked based on what counts were being considered at that time. And so we knew that a verdict was close, and it was hard to hear, but we had heard it sounded like when she had gone into Judge Edelman's chambers that she said, "We have a verdict." And so that was when the parties started coming back in, and you could tell that the defense team, I mean, it's a moment where you've been working towards this moment for months now, as Hannah Dugan's defense team had, and as had the prosecution, but obviously a lot on the line for Judge Dugan and her career. And coming in, and there was a palpable, I don't want to say somber, but you could tell that there was emotion there as they came over to the defense table and turned around and stood and waited for the rest of the parties to enter into court. From my vantage point, I couldn't see Judge Dugan and her reaction when that verdict was read because her back was faced towards us. But before they sat down, I did see Nicole Masnica, one of the defense attorneys, rub Dugan's back in a comforting manner as we were all waiting for Judge Edelman to be back on the bench and for the jury ultimately to be brought back in.
Bill, you have had your ear to the ground. You've watched everything that's happened in the courtroom. We were wondering if Judge Dugan would testify, and you got an early indication that she would not. Talk about that.
Yeah, it was at the end of testimony, or it was during a break in the testimony yesterday when there was a game plan being discussed between the parties and the judge as far as how much time was going to be left on the government's case, how many witnesses were going to be left, and then what type of timeline that the defense might need in order for it to put on its case in chief. And there was a conversation, again, hard to hear in this large courtroom, but one of her attorneys, Steve Biskupik, said that she is not testifying, but again, ultimately said that it is up to her. So obviously that was still maybe in the cards, but I think some of the legal experts could be better at speaking as to whether or not it would have been a good idea if Dugan took the stand in her own defense. But coming into the day, we knew that there were going to be 4 witnesses that the defense was going to call, and they had said that they were going to be wrapping up before the noon lunch hour or by the noon lunch hour with those 4 witnesses. So kind of doing the math, you would think that if there were 4 witnesses and saying that they're going to be wrapping up before the lunch hour, that Dugan would not not be testifying, because you would expect that there would be a lot of direct examination by her defense team and significant cross-examination by the government.
Guys, it always amazes me that we can get 12 people to agree on something. Try and do that. Just get 11 of your friends and try and agree on anything. Here, they agree on both counts, Bill. And it took them several hours, but they seem very focused, and they were asking very specific questions. We could not see the jury throughout the week. What was their interaction like? They seemed like they were just on point throughout this trial.
Ben, just a quick correction. Did you say that they agreed on both counts?
Well, they came to unanimous decisions on the not guilty and the guilty verdicts.
Yes.
On the verdicts.
Yes, absolutely.
They all agreed on not guilty,
yes,
and they all agreed on guilty on the 2 counts.
Yeah, just it was hard to hear. Yeah, so it definitely, the jury was very much paying attention during the trial. It didn't seem that there was maybe much nodding off, as sometimes we've seen in state courts. I believe maybe some of the driest testimony, because it was very repetitive, was some of the government's first witness, the FBI Special Agent Aaron Luker, really kind of laying the groundwork for what was going to come. So I think that was maybe some of the more dry or repetitive testimony, but definitely the jury was engaged throughout that trial, nodding along, listening to when the government and the defense were making their cases.
Bill, you were in the courtroom, and so we haven't had the opportunity to see exactly what was going on because it's the federal rules. We just had sketches. So when Judge Cervera was testifying, what was that like? Could you feel tension? What was Hannah Dugan doing? What were the jurors? Who were they focused on?
Again, unfortunately, from my perspective, I was smack dab in front of a television screen where exhibits were being displayed that blocked my view of the witness stand unless I craned my head into someone else's lap to try and look around. So I couldn't really see the witness stand throughout the entirety of the trial. But you could definitely hear in Cervera's voice and how she was talking that it was definitely an emotional time for her to be on the stand testifying against a fellow judge for the government. And you could sense in how in speaking to is essentially what she said on the witness stand, that she was hurt by what happened. She was upset, she was angry of her saying that she got pulled into this and not knowing what she was getting pulled into.
Do kind of wonder what things are going to be like for Judge Cervera in court after all of this, especially after essentially coming into direct conflict and being the state's star witness against Hannah Dugan in this case. She's got to go back to that courthouse where many of Hannah Dugan's allies are and go back to normal operations. It does seem like that would be difficult. I don't know if you heard anybody talking about that, Bill, but that's got to be a really interesting situation.
Yeah, I wouldn't be able to speak to that.
Yeah, Jonathan, I mean, it's Milwaukee. We always talk about that. You meet somebody once, suddenly you see them at the grocery store. The legal community, even smaller. I mean, everyone who got on the stand knows each other or has heard of these people. And now, wow, talk about awkwardness moving forward between everyone who just talked. That's what made, I think, this so fascinating.
Your boss, the chief judge, also testified for the government.
It is going to be very awkward around the courthouse because people have sides and factions and those types of things, and I think it's going to take a while for everyone to kind of get through this. But boy, when you have judges testifying against other judges and the chief judge, it really made it a messy situation, and I think the courthouse is going to be a little bit shaky for a while.
And what happens to all of Hannah Dugan's cases that her court has gone dark, essentially?
So her court is being manned by a substitute judge right now. So if she no longer is the judge, if they remove her, there'll be a special election or an appointment into that position.
But as we said, that's not going to necessarily happen right away because of this process that's going to happen before the judgment of conviction. Is that right?
It's hard to say, but we now have a guilty verdict. It's possible that there could be some movement.
Or a resignation.
And anything's possible at this point.
Now, I know
right now she's been on paid leave. So.
I saw in our notes here that at some point Christina Van Zels was with a couple of demonstrators who were out there. There were 2. I don't know if she's there, if she's with them, if we can go to her. Maybe somebody can let us know. But if so, that would be something. We do not have her right now. Okay, we'll try to check in on that a little bit later on. a remarkable day, though. What has it been? It's been more than 12 hours, almost 13 hours. And Bill, I just think, I've said this all along, this is a really unusual trial to cover because we're used to having video, we're used to having audio, and we had to rely on not only your eyes but your fingers because you were typing these live extemporaneous notes. That means you had to have rapt, focused attention at all times. How'd you hang in there?
Not enough coffee, I could say that. But, you know, it's definitely something to try and take in everything that is going on and try and distill it into something to help colleagues out and help our viewers out to better understand what is happening inside that federal courthouse. As, again, you know, audio recordings and video aren't allowed. So. Definitely a lot of work, but definitely something that we all have put a lot of work and effort into to bring to you and our viewers to provide context and perspective as to what was going on here at the federal building.
Bill, the government really created a story here, as I'm sure Jonathan Lavoie will tell you, every lawyer does in a case, every trial here. What do you think was the most critical piece of evidence here? Because we heard audio recordings for the first time where we could hear Judge Dugan say down the stairs. There's obviously surveillance video and then this testimony. What moment stuck out to you through this week?
I think some of the moments that stuck out to us were Judge Cristela Cervera's testimony. That, I think, was very impactful for the jury as it really tied together portions of the government's case. Chief Judge Carl Ashley's testimony, as well as that of Judge Hannah Dugan's court reporter, Joan Butts, and detailing on the stand what some of those conversations were that were captured by the digital audio recording system that's used in the courthouse to help those court reporters if cases aren't being called on the record. And ultimately that, as well as the testimony of Dugan's own deputy court clerk, Alan Freed, I think was also very impactful as it came to explaining what those conversations were, the intent or mindset of what the government's argument that Hannah Dugan had at the time that she took those actions that she did.
All right, Bill Miston, thank you. We're going to take a quick break and reset, but if you're joining us, Judge Hannah Dugan guilty of obstruction, not guilty of helping a man evade agents. We'll be back right after this.
Fox 6 News.
And the breaking news we've been covering, we do have now the verdicts in the Judge Hannah Dugan trial. Dugan found guilty of obstruction, but not guilty of helping man evade federal agents. And so what does this mean going forward? We know that we heard from her team saying that this is not over.
Gentleman Lavoie is here, our legal expert. What kind of punishment is she facing now?
So the good news for her, Judge Edelman is a very compassionate judge. He's a very long-standing judge who's been around a very long time, and he's known to give consideration to criminal defendants and give people the benefit of the doubt. Judge Dugan has no record. She's a public servant. While this case was serious, there was nobody injured, nobody harmed. The suspect was recovered. I suspect that the punishment will likely be some type of supervision, some type of probation. I think it's very unlikely Judge Edelman will lock her up or put her into a jail setting. There's a possibility of house arrest. There's a possibility of, again, some type of probationary status for her. But I don't think the punishment's going to be difficult. I think the punishment for her is the felony conviction and the loss of her her job.
Speaking to what you said, by the way, you said you don't think that Judge Edelman will lock her up, but we did get one statement from a politician already, Representative Tom Tiffany, who tweeted out on X, "Guilty, now lock her up. Hannah Dugan obstructed federal agents attempting to arrest an illegal alien with a violent criminal history, including strangulation, suffocation, battery, and domestic abuse." Though I don't know that he was ever convicted of strangulation and suffocation. Is that right? But that was in the tweet. So we did hear that. That's what one politician is calling for, but you're saying it doesn't seem likely that's going to happen.
Judge Edelman will absolutely not be swayed by politics. He will not be swayed by the media. He will not be swayed by tweets. I believe that he will do his job as he normally does. I think he'll assess the federal guidelines appropriately, and I think she'll fall into a category of very low risk and no need for any significant punishment or incarceration.
There have been a lot of people that the point they were trying to make when they were reading about this case was no one is above the law, and that includes a judge. If there's a lenient, per se, penalty, a lot of people may be upset by that because there are a lot of people who think that there needs to be some punishment for what has happened.
That is true, but as we talked about, having a felony conviction when you're a sitting judge is significant punishment in and of itself. She's been through the ringer with all of this publicity and this public trial, the national news attention. Judge Edelman has to focus on federal sentencing guidelines, and he is not going to deviate from what he normally would do. He's used to sentencing very violent offenders or offenders with significant criminal histories. She really comes to the table with a fairly minor case in the grand scheme of things where no one was, again, injured. This wasn't assaultive. This was, as Mr. Schimmel said, a one bad day situation.
I tried looking at those federal guidelines because there's certain levels that every offense fits into, a level 10 or a level 20 or whatever. And then you start adding more things, and I realized this is way beyond me. I can't even come up with any kind of estimation of what she would face.
Right. Mr. Santelli told you that they're going to do a pre-sentence investigation and determine the sentencing guidelines for her. So that's a whole process where the Federal Probation Department will go through the entire case and make a recommendation of where she falls under the guidelines, and then the judge will either adopt those guideline recommendations or could change those. But ultimately, no matter what the guidelines say, in federal court now, the judge has the final decision, and sentencing guidelines are advisory.
Let's go to Jim Santel. I mean, who better to talk to the federal guidelines of what the judge will be looking at here? So what will the judge be deciding?
Jonathan's got it just right. She will almost certainly fall in the lowest of low categories. This has been in place for many, many years, but Jonathan also accurately noted that based upon a Supreme Court case of many years ago coming out of Wisconsin, they are advisory, which means that they're not compelled. The judge does not have to sentence within the particular category. But even putting that aside, this will be a low determination in terms of her exposure, and the judge will sentence her almost certainly to some term of supervised release. There could be some modest fine here as well, but that's almost certainly what the disposition is going to be here. If I could comment again upon some of the reporting also about this coming from one of our congressmen too, the notion that tonight we would once again invoke this notion, lock her up, is a complete refutation, a rejection of everything that America stands for. We just went through a trial, Representative, where we provide due process. There's a grand jury system that returns a grand jury verdict. We bring the defendant in, advise her of the charges against her. There are motions that follow that. They're resolved by a judge. We have a trial by a jury of her peers. Unanimous decision, beyond a reasonable doubt. There will be all this other process that we just talked about. We do not simply lock people up in America. And I find that offensive as a former prosecutor.
Can we talk about the jury here? Do you guys think there was a one holdout, a couple holdouts on both different counts here? Do you think they were all kind of in agreement on both sides? What happened, do you guys think, in that jury room tonight?
The most common question we as lawyers get is what happens in the jury room. Yeah. We're as stumped as you guys are. We don't know sometimes, and anyone's guess what they were talking about and fighting in that jury room about, or what they were discussing. It is a sacred room that only the jury knows, and they can talk about it if they want, but they don't have to. So we will never know unless one of the jurors happens to give an interview and talk to you guys.
And they got out of that courthouse, it would seem, with a lot of haste. So maybe as we go down the road, they may feel more about talking about what happened, but so much pressure on this jury, knowing that so many eyes were on this case around the country.
I want to repeat for people who are just joining us, you've heard us talk a lot about the split verdict, but there is not an immediate judgment of conviction. The defense, Stephen Biskupik, has said that they've requested a briefing schedule, and that means they want to argue that they think that this split verdict doesn't make sense for a jury to come to this verdict, that he doesn't want the judge to enter this judgment of conviction. And so the two sides will enter over the next 3 months into a battle of briefs to try to get the judge to either uphold or to reject this jury verdict.
And jurors aren't
this
lawyers.
Is a long way from
so
over.
Jurors potentially could screw up a decision because they're not making it based off of, right? They're not experts in this. They've come in blind. So is that correct, Jonathan?
That's sort of correct, but really, at the end of the day, the jury is making a judgment call. You know, really, they had to find that she had the intent to do so. That's really what the biggest issue is. The judge is never going to supersede a judgment call decision by a jury. A judge would only overturn a verdict if there was a major, factual issue or an issue with regards to jury instructions.
Something brought up that shouldn't have been.
Something like a legal issue, not a judgment call issue.
And these were jury instructions that the judge made decisions on, so he would be almost ruling against himself, wouldn't he?
It would be unlikely the judge would overrule his own decisions. That would be something that might be on the Court of Appeals.
And he gave these thoughts. I mean, each time the question, especially the second or third question, they went back in the chambers. It wasn't a quick decision from him. He was presumably
went to meet with his clerks and talk it over.
Thinking of the legal issues behind that question, right?
Right, because he knows how important it is. He knows that the jurors are hanging on his every word, and every single word that he writes back to them or tells them matters to them.
And it did. It appeared.
And it did as it appeared.
Now, procedurally, up until now, throughout the pendency of this case, the Wisconsin Supreme Court suspended Judge Dugan. I believe it was suspended with pay, correct?
Correct.
For the pendency of this. Because there is not yet a judgment of conviction, does that suspension simply continue? When she wakes up tomorrow morning, she doesn't go back to work on the bench in the meantime, right? I mean, this continues, or do we know how this works?
I suspect that at least the suspension will continue. Whether they take it to the next level, whether they wait or not, is anyone's guess at this point.
Let me ask you this. Politics, how well did the defense keep politics out of this? How well did the government keep politics out of this case?
So I thought that the defense did a good job of actually trying to weave politics into the case.
Get more of it in there.
Even though they weren't supposed to, they knew that that's an important issue. They wanted to play to jurors that were potentially had feelings about immigration a certain way. The prosecution, they wanted to avoid it, right? They wanted to stick to the facts. They wanted to talk about the hallway and the stairs and what did Judge Dugan say during this hushed remarks. So each side played their cards the best they could, and I think the jury, waded through all that evidence, and this is our verdict.
I go back to the comment that Jason Luzak said during his closing argument that essentially you are the last check on government overreach. He didn't say the overreach of the Trump administration, but that was the seed he was trying to plant at that time, right?
It certainly was. And then when they called Tom Barrett as their last witness, again, he wasn't there. It really had a little bit of a political aspect to it, trying to appeal to people, I think, that are, again, anti-Trump immigration
But
process.
in the end, we know that they looked closely at those specific elements as opposed to ruling or voting based on emotion. They looked at those elements so closely, they really challenged the judge to explain to them what he meant.
And that's the great part about it. The jury listened to the judge, and I think tried to get the noise out of it and focused on the elements, which is where they should be focused.
And hanging out there, there's still no policy for Milwaukee County. The chief judge still just has a draft.
Jonathan, thanks. James Santel, thank you. We got to get to Fox 6 News at 10. We'll be right back.
with stories that matter to you. Fox News at 10 starts right now with breaking news.
When someone, especially a sworn public official, puts them in unnecessary danger by obstructing those efforts to make an arrest as safely as possible, they must be held accountable.
How can you find guilty there and not guilty on the first? I would just say the case is a long way from over.
Now on Fox 6 News at 10, guilty. A split verdict reached in the federal trial of Judge Hannah Dugan. It took a jury just over 6 hours to reach their verdict tonight.
Judge Dugan facing 2 federal charges. She was found not guilty of count 1. That's concealing from administrative arrest. But she was found guilty of count 2. Endeavoring to obstruct proceedings, a felony, and take a look at this new sketch of Dugan from the verdict reading.
Now, okay, let's bring in our team that is outside the courthouse. There is the picture that was taken from that court drawing at the moment this verdict came down. Let's start with Bill Miston outside the federal courthouse. Bring us to the moment, Bill, when that verdict came down.
Well, it was right around 8:30 that we heard a knock on the jury door, and a court security officer had gone in. There had been several times that jurors had questions throughout the night. That court security officer came back without a slip of paper and walked into Judge Adelman's chambers. Overheard her saying, "Judge, we have a verdict." Then parties started coming back in the courtroom, including Judge Hannah Dugan and her defense team. Before sitting down at the defense table, Nicole Masnica, one of the defense attorneys, comforted Dugan, rubbing her back as the government also came in and awaited the jury to come in with its verdict. And as you said, ultimately, Judge Hannah Dugan found not guilty of count 1, a misdemeanor of concealing a person from an administrative arrest. But the jury did find her guilty of a felony, count 2, of endeavoring to obstruct proceedings. Now, her defense attorney said after the hearing, after the verdict was read to the media, that this case is far from over, and there are going to be several motion hearings set in the coming weeks and months, as it was a split verdict. And Steve Biskupik, a former U.S. attorney here for the Eastern District of Wisconsin, said that there are elements that are present in both of those counts, and no doubt would be filing motions to take a look at how the jury could convict on one count but find her not guilty on another. We also did hear from interim U.S. Attorney Brad Schimmel, former a judge out in Waukesha County and former prosecutor as well, and he did speak about the prosecution's case, and again reiterating that no one is above the law.
Bill, thank you for that. In fact, we do have those sound bites. We're going to hear from Brad Schimmel, U.S. Attorney Brad Schimmel, right now. He gave reaction shortly after the verdict came in. Let's hear what he had to say.
Some have sought to make this about a larger political battle. While this case is serious for all involved, it is ultimately about a single day, a single bad day in a public courthouse. The defendant is certainly not evil, nor is she a martyr for some greater cause. It was a criminal case like many that make their way through this courthouse every day, and we all must accept the verdict peacefully.
Then there was a fascinating moment because Bill, the defense team, walks into the room and kind of moves Brad Schimmel out of the way. Let's play the soundbite, and then we'll get your reaction on the backside, Bill.
Just the defense comment is obviously disappointed. The mixed verdict is the big thing from the defense perspective. You know, the same elements of count 1 are in count 2. In count 2, how can you find guilty there and not guilty on the first? But that's why we asked for the post-trial briefing. Judge hasn't set a sentencing date, so obviously he's going to take this seriously as well. And I would just say the case is a long way from over. Thank you.
And that was interesting because Brad Schimmel comes back in. But Bill, the fight is not yet over. This thing continues on, according to the defense team.
Yeah, just to take people back through this trial, the trial lasted 4 days of testimony. The government's case, 19 witnesses, more than 15 hours of witness testimony from the stand. Today, Judge Hannah Dugan's defense team called 4 witnesses to the stand, including 2 Milwaukee circuit court judges and former mayor Tom Barrett. Their defense, though, spending only about 45 minutes in total. Tom Barrett, a character witness for the defense, and then closing arguments. The closing arguments began late this morning, and then the jury had the case at around 2:25 this afternoon. And really throughout the afternoon, there were several questions that the jury had asked. The first one relating to whether or not Judge Hannah Dugan needed to know who that administrative warrant was for in order to conceal him, Eduardo Flores Ruiz. That is a person that an ICE Enforcement Removal Operations Task Force was in the courthouse that day on April 18th to arrest. Whether that Judge Hannah Dugan needed to know who that individual was based on the reading of the instructions or elements of that count. And Judge Edelman said that and needed to know an individual was part of those instructions. So presumably that is how the jury came to a conclusion on that count. And really, again, yet to be seen on how Dugan's defense team is going to file these motions ahead as they try to figure out how the jury convicted on one count but didn't on the other.
Bill, before we let you go, you were there about 7:30 when Dugan walked in. You were there when the jurors got called back in, when the judge. Did you sense the mood of the courtroom, and did you see any body language, any expression from Hannah Dugan?
Well, I think when that first question came back as to what the jury needed to consider for that first count, I think there was definitely a change in the defense's step as it seemed more of like a, I don't want to say a victory, but that it was going in their direction. And then kind of harder to read when that second question came in from the jury as to count two. But, you know, as far as Judge Hannah Dugan's reactions, it was hard to see from my vantage point as her back was faced towards the gallery as the tables for the government and the defense face the dais of where Judge Edelman was seated. So could not see her reaction when that verdict was read, but do know that before they sat down, I mean, it's a very difficult thing, right? Judge Hannah Dugan and her career on the line, and coming in a jury of her peers, of people from the Eastern District, ultimately came and made a decision on both of those counts.
Bill Misson, great stuff outside the federal courthouse. I got to get to Ted Perry and Christina Van Zels. They're outside the courthouse as well. We didn't see Judge Hannah Dugan leave the courthouse, guys. Looked like, I mean, cameras all over the place, but it looked like she got out of there fast tonight.
We assume that she did get out of here pretty fast, guys, because as I was walking out about 15 minutes ago, I said to one of the court security officers, has the judge left yet? And without being committal, he said, she probably has. So I agree with Ben that she probably scattled got out of there as quickly as she could. We want to talk more about that really interesting moment where Brad Schimmel, the acting U.S. attorney, was talking and then was interrupted by Stephen Biskupik, who wanted to make a quick statement. And you saw that from a perspective that no one else did. Tell us about that.
Yeah, so as you guys know, we were in that media broadcast room. That's where all of the news outlets were set up for anyone who wanted to speak after a verdict was read. I was on the outside of that door just kind of checking in to see if people were in line to speak, and that is where I ran into the whole defense team, and they asked me, how much longer is he going to be talking? All kind of looked at each other and said, we're going in. And then you were in there, in that room, in those moments.
And that's when Biskupik came in. How did they decide it would be Stephen Biskupik to go in? Did they all look at each other and point at him? How did that work? He is technically lead counsel.
I'm not privy to that. I'm not sure how they decided it, but they did all kind of make eye contact with each other, almost with irritation. They wanted to get in there and make their statement and leave. It's been a long day, but I'm not sure how they decided who would actually be making that statement.
That's a really interesting perspective on your part, because I was back at our little makeshift studio there behind the bank of reporters, because I was still on the air with Ben and Kim and all of our guests, and Mary was about to join us. And we saw Brad Schimmel come in. very judicial. Of course, he's been a judge. He's been the Attorney General. He is now the U.S. Attorney General, acting U.S. Attorney General. And the temperament, I thought he showed a lot of grace when Biskupic came in, made his statement and left, and really tried to, and Ben made this point earlier, and I agree wholeheartedly, really tried to bring down the tone. Wasn't spiking the football at all, wasn't doing a victory dance, saying, it was a bad day, a bad decision on a bad day, and let's not make any more of it than that. So, guys, I'll send it back to you in there, but that was the perspective in room 190, the only room we're allowed to broadcast from inside.
Right. All right. You guys, thank you for your coverage there. We want to bring in our Jason Calvi. He's lied outside of the courthouse. He's been at the Milwaukee County Courthouse for pretty much the duration of this trial because, as we've been telling you, cameras allowed in the federal courthouse. So we appreciate your illustrations out there. Jason, you talked about a real flashpoint earlier in the day that could have played a role in this verdict tonight. Bring us up to speed.
Yeah, the jury asked two questions. They asked for clarification from Judge Edelman on two particular questions. In the first question, it seemed like the judge sided with the defense, and that was about that misdemeanor charge, and that's the one that she was found not guilty of. And then in the second, the final question, the Judge Edelman, seemed to side with the prosecution, and that was over that felony charge, and that's the one she was found guilty of. So we'll talk to the legal analyst about that one later. But, this issue really is tying in with that national debate over politics of immigration. You're thinking about the debates. We've had fierce debates the whole year about immigration arrests and deportations and the role of judges. And that's all played a key role in this debate. Judge Hannah Dugan, a sitting judge, taken out in handcuffs. That was an image that the FBI director tweeted out on social media, a picture of that, of her being escorted out, taken out in handcuffs to the Milwaukee County Courthouse back in April. And it's been really gaining the nation's attention when you think about immigration and arrests and the role of judges in our country. What was interesting in the closing arguments, and I was in the court for some of those closing arguments today, the prosecution really said this is not a referendum on ICE. Whatever you've seen, whatever you've heard about the debates about immigration arrests in other parts of the country, in other cities, there's been fierce debates and protests, maybe in places like Chicago. Don't pay attention to that. That's what the prosecution said. The prosecution said, the jury, your only role here is to decide the facts in this case. So that national debate over immigration played in the closing arguments. We also heard from the defense. The defense talking about the national repercussions of this particular case in their closing arguments, saying that the federal government wanted to make an example of Judge Dugan. And the defense said to the jurors, you are the ultimate check on government overreach. So you saw the defense making an issue of politics in their closing arguments, talking about how there was a change in administration this year, and then that led to changes for ICE. But at the end of the day, the jurors had the decision guilty of that charge of obstructing federal proceedings, obstructing those federal agents, but not guilty of that misdemeanor of helping Eduardo Flores Ruiz escape and evade arrest at the hands of ICE. So guilty of the felony, not guilty of the misdemeanor.
All right. Thank you, Jason, for breaking that down for us. Well, tonight's deliberations went on for hours, started about 2:25, ended about 7:25 in the federal trial of Judge Hannah Dugan.
This after the defense made their case today. Both sides, they presented the closing arguments, and then we got this really historical split verdict. And we need to break it all down with us, and we don't know how to do that without this man. It is criminal defense attorney Jonathan Lavoie. He's in studio. We'll get his takeaways live next.
It's the year-end. You're watching Fox 6 News with Ben Handelman and Mary Stoker Smith.
Back now, the jury deliberated in the Hannah Dugan trial for really just about 8 hours today.
It was a long time. Split verdict. And joining us now, it is our legal expert and criminal defense attorney for Kim and Lavoie. It's Jonathan Lavoie. So interesting. A split verdict here. Guilty on felony obstruction, not guilty on the misdemeanor. The defense is coming out and saying, well, wait a second. These had similar elements. You can't find her guilty on one and not guilty on the other, or vice versa. Does that argument stand up?
Right. Stephen Biskubik, made a comment that this makes no sense to him, that the elements line up between these two offenses. How is it possible for the jury to find her guilty on one and not guilty on the other? So he's going to raise this to the judge and say that no reasonable jury could do that, and I'm certain they're going to raise issues with regards to the jury instructions. So there's going to be a continued fight in this case, even over the next couple months until the judge makes final rulings on the verdicts.
We heard people like Tom Barrett today talk about her character. He was brought in. Clearly that was a bit of a political move. If the defense dropped the ball in any way because of this one guilty verdict, if they did, what would that have been? Well, she was convicted of the obstructing, okay? And we know the strongest argument for the state was that she directed them to the hallway. The defense never explained anything about that, never explained what she was doing. They left it alone. They never talked about it. And it was kind of an unanswered question. So, like I said yesterday, having her testify to explain what was going through her mind, what her intent was, might have helped explain to the jury what her intention certainly was by putting them in the hallway. Because remember, they entered out right where the ICE agents were and not down that stairwell. And you mentioned that a couple times today.
Why did she not? At the end of the day, why did she not go up on the stand and explain exactly what you just talked about?
She could have said, I was thinking about doing it. I got to the point where I got him in the hallway. I decided I didn't want to send him down the stairwell, so I sent him back out to the ICE agents.
She also would have had to tell the truth and some very, very smart people in that room who would have caught her in any lie.
Correct. And she can't perjure herself, and we don't know what her true story is. But what I do know, it was a void for the jury because they know that she was whispering, talking about the stairwell, and then directed them to the hallway, but it was never addressed by the defense.
Right, and that audio that we heard, albeit grainy, seemed to be a sticking point there, where even if you felt that she could have not been doing anything wrong, it was hard to avoid that. This all came down to, in a lot of ways, to obviously that hallway, that stairwell, but also people's thoughts about immigration. Even if you had those 12 jurors all saying, listen, we don't believe in the current direction that illegal immigrants should be taking in our country, did they have enough that they could have said, there's no way, we can't convict her on this one charge, on the felony charge?
Well, the defense was trying to play into the hope that the jury would fracture and split, and that certain people simply would not convict her because of their beliefs and convictions about immigration. Ultimately, the judge, of course, told the jury, do not consider those things. And I think the jury spent most of the time on the elements and the appropriate things. And I think the jury, I'm always very happy that jurors spend the time and effort that they do, and we're so thankful for their service. But I think this jury really did a good job, and you could tell that they cared and they spent time on this case and looked at the elements.
Jonathan Lavoie, Kim and Lavoie. I'm not sure I would have understood any of this if you didn't help us throughout the entire week, so thank you. It has really been fascinating to watch this all unfold.
Yeah.
Thanks for having me.
Really appreciate you being here. Tom, you were keeping a close eye on the weather as well, because we have some situations out there.
That's right. Well, you feel the cool down, right? And the wind is just howling tonight. Let me start out by telling you that the roads, all in all, look okay. We don't have any major issues on the roads. That being said, still some patchy, icy spots will be possible, and we could see some snow coming through overnight, especially north of Milwaukee. So just be careful if you're walking the dog, if you're on the sidewalks, parking lots, driveways, things like that overnight. But the wind, even though it's brutal tonight, it has actually helped us in the sense that it's dried out the roads, so we are not seeing massive icing that we were fearing earlier. So that's at least good news to report there. But check this out. We are now at 19. That's after a high of 48 in Milwaukee today. We're down about 30 degrees from where we were early this afternoon. Now with a strong west wind, look at this. It feels like 4, and we always talk about the dew point, right? Now it's in the single digits because the cold air mass has arrived. Our air pressure, which bottomed out very low today, about 29.23 inches of mercury, that's coming up tonight. It's still very low, but that is on the rise. All right, so temperatures very cold. And again, many areas already dropping into the teens here tonight. Wind chills by morning will be between 0 and -5 because these wind gusts that are gusting over 30 miles per hour will continue into the morning hours tomorrow. Then the wind will get lighter during the afternoon. But take a look here at temperatures from across the state. It's brutally cold here towards Minneapolis, Rochester, Minnesota as well. And that air is heading in our direction. So it's not only the air temperature, but it's also the wind chill. Now, let's talk about what's going on in terms of the radar, because we do have some snow. It's falling apart a little bit as it's approaching Wisconsin Dells tonight. I don't think we're going to get a lot out of this. In fact, I think a lot of it's going to start to fall apart. But especially north of Milwaukee, we could end up seeing just a little dusting here and there. And because it's so cold, it'll be that fluffy variety of snow blowing around. So we may see just a little bit of that overnight tonight. Taking a look at the watches and warnings, there are winter weather advisories up to the north for some of that snow and also those freezing temperatures as well. Earlier tonight, there were blizzard warnings in southeastern Minnesota. So let's get into Sky Vision Plus. We have a lot to go over here hour by hour. And starting you out in the morning, air temperatures here will be in the teens. But again, wind chills between 0 and -5 as you head out the door in the morning. We're not going to warm up a whole lot during the day. Temperatures in the teens at noon, maybe low 20s if we get lucky for a high tomorrow afternoon. I think wind chills will largely be around 10 during the afternoon. So it is going to be a cold one tomorrow. As we head through the overnight, there's some of that light snow coming on through. It stays windy into the morning. Skies become partly cloudy as we go into the afternoon. And then Friday night largely looks dry, but we may have some precipitation coming in as we head into Saturday. Right now, this looks to be on the light side. So stay tuned for that. 40 on Saturday, 22 Sunday. Then we're back up to 40 by Christmas Eve and maybe 50 on Christmas Day. That's your latest forecast. We'll have more news for you after the break.
continue to follow this breaking news. The outcome of the federal trial for Judge Hannah Dugan. It took a jury over 6 hours to reach their verdict.
Judge Dugan faced 2 federal charges. She was found not guilty of count 1, concealing from administrative arrest, but she was found guilty of count 2 right there, endeavoring to obstruct proceedings, and that is a felony. Let's bring in UW political expert, UW Milwaukee professor emeritus, Mordecai Lee. Mordecai, you've been here with us for days now during this trial. First and foremost, before we get to the specifics, give us your initial reaction, particularly since the jury started deliberating just after 2 today and just wrapped. They finally entered the courtroom again with their verdict at about 7:30 tonight.
I was just astonished. It was really important that they took the time to get into the details, and they sure burrowed in to get down to some of the elements of the difference between obstruction and concealing. This, I think, is going to be politically an electrifying event. This is astonishing and surprising. And I guess we could take the larger look at it and say that civil disobedience is an honorable activity in American history. But civil disobedience breaks the law. And today what we saw, the jury said, we might have some political sympathies or antagonisms, but we're going to look at the facts. And so they split the difference, it seems to me, in a very specific way, saying the rule of law is consistent. And she broke the law in one respect, and she did not violate the law in the other. So politically, people who are on the left are going to be happy and sad. People on the right are going to be happy and sad.
And Mordecai, here was Brad Schimmel in the courthouse appearing to speak to exactly what you are talking about. Because when this case started and the charges came down, we saw the FBI director releasing the photo of Judge Hannah Dugan in handcuffs and the politically charged sentiment that was really out there on both sides. Tonight, that's not what we heard from Brad Schimmel coming out of the courthouse. He really was trying to tone this down and say this was a typical court case. There were facts here, and the jury is going towards the facts.
Yeah, he was really walking a tightrope because he didn't want to antagonize the people who might nominate him to be the permanent U.S. attorney. But on the other hand, he's from Wisconsin. He understood exactly the emotions that were going on. I would guess that by tomorrow morning's news cycle, we're going to have the administration giving their word. We might even see President Trump commenting on social media. And we're also going to see her defenders. There may well be a rally by her defenders tomorrow. To them, she's a martyr. But, you know, she's a martyr because she was willing to try to break the law. She said in one of the pieces of evidence, I'll take the heat. Well, she is taking the heat. She's going to lose office automatically as a convicted felon, but not until Judge Edelman enters the verdict. There's an outside chance that he would overrule the jury. I doubt it. But when he enters the verdict, at that split moment, she'll be a former judge, a convicted felon.
And we'll see where she goes from there. Okay, Mordecai Lee, thank you so much for all of your analysis during this entire trial. And thanks for joining us via Zoom tonight at 10:28, a late hour for you. Appreciate it.
Appreciate it. More Fox 6 News coming up in a second.
Fox 6 News is live and local.